Chief Justice and the Justices of the Court, I, together with my learned friends, Mr. Deval, SC, Ms. Palmer, Ms. Tlogo, and Ms. Louis, appear for the applicants in the ICA case.
Thank you.
Chief Justice, members of the court, I appear together with my learned friends Mr. Nasseruddin and Mr. De Beer. We appear for the President of the Republic, who abides, and we appear for the Minister of Home Affairs.
Thank you very much.
Chief Justice, members of the court, I appear together with Ms. Zikalala and Mr. Solik on behalf of Parliament in both matters. That's the second and third respondents in the independent candidates matter and the fourth and fifth in the OSA matter. Thank you.
Thank you.
Chief Justices, I appear for the Independent Electoral Commission in both matters. My learned friend Ms. Blizzard, who prepared with me, is unable to be present today.
Thank you.
Chief Justice, together with my learned friends Mr. Suleiman, Ms. Mudli and Ms. Mdleche for the applicant One South Africa movement.
Thank you very much.
Lastly, Chief Justice, Justice of the Court, together with my learned friends Ms. Maharaj Pillay and Ms. Creyer, I appear on behalf of the Amicus Curiae Rivonia Circle.
Thank you very much. Council will observe that only one matter was called. That's because we prefer to start with this matter, finish with it, and then move on to the next one. So for now, we will deal only with the Independent Candidate Association matter. Thank you. Just so that members of the public who might not be aware of the recent directions understand what is going on. Council who appear for the parties are given 30 minutes to address the court without the court asking them any questions. But when the 30 minutes expires, and then they've got to stop. There's a timer there which is operated by a clerk. At the end of your time, we will hear some noise, and then that will mean you have to stop, and then you can only answer questions from the bench after that. Thank you. Your 30 minutes starts now. You are always free to say, I don't need 30 minutes.
The last time I made that invitation, I got myself off the tracks. Chief Justice and the Justice of the Court, I just want to make a disclaimer up front in this case and say that I do not profess to know anything about mathematics and statistical calculations. And as a result, Mr. Deval, who will be arguing a part of this case, will deal with those portions of the case.
Okay, okay. So how much time of the 30 minutes will you take? I leave it to you, the two of you.
Our arguments have been divided into two parts, and will be shared between myself and Mr. Deval. And I will deal, I meant to deal originally with principally the direct access, but I see that in the papers there's no contestation on direct access, so I will not deal with it unless being raised in response. Therefore, I'll be dealing with principally what I would term the infringement claim of fundamental rights, and I'll come back to what that claim is. And Mr. Deval will deal with what I would call justification of the measures taken by Parliament in creating a 200 split in the legislation which is impugned in these proceedings. Whether that he will do that under either the rubric of justification or under the rubric of arbitrariness or justification.
Yes, as long as you remember that if you forget to look at the watch and you don't give him time, his 30 minutes is up, it will be up. He won't have another time.
For those reasons, I'll take 15 minutes in my argument
Yeah.
of
Okay.
uninterrupted time.
Okay.
The question in this case, as we say, it is whether the method or the formulae for allocation of seats which appear in the Amendment Act for the allocation of National Assembly position adequately complies with what has already been a vindicated right of independents to contest elections without joining political parties. And heads have been filed by parties in the past few weeks, and those heads exchanged in our submission have somewhat crystallized the issues or the issue in the case. And I would submit, Chief Justice and Justice, that the question in this case is this: is an electoral system which accords independent candidates an opportunity to contest only half of the seats in the National Assembly, but by contrast accords political parties an opportunity to contest the entire 400 seats in the National Assembly. That decision has been chosen primarily in order to avoid a negligible or remote possibility of an overhang. Is that measure constitutionally valid? And we submit, for the reasons which I will outline, that it does not. It constitutes in our submission a breach of fundamental rights which have been identified in our heads of argument in section F at paragraph 36 of our heads. And those rights are section 19(2), rights to free and fair election, and right in section 19(3), right to vote or stand for election, and to some extent the right in section 9(1), the Equal Protection Clause. We premise our infringement claim to those fundamental rights on pronouncements by this court in a trilogy of cases. The first in that trilogy is a judgment in New National Party, and we rely particularly in paragraph 11 of that judgment, where 2 points are made. The first is that the right to vote is a fundamental right to democracy. And the second point is that the mere existence of the right to vote without a proper arrangements being made for effective exercise of that right is both an empty and a useless right. You'll find that in the last sentence of the judgment in New National Party. The second in the trilogy is a judgment in New National Movement at paragraph 16, where reference to the case of Mazibuko was made by this court, the judgment of Justice Jafta, where he held that section 46 of the Constitution does not empower Parliament to make legislation or to make rules that render constitutional entitlements worthless. He also continues referring to the judgment of Mosenege DCJ in Mazibuko, where that court endorsed or just rejected the notion that the Chapter 4 processes, which is the 4 processes of Parliament, including composition and election of National Assembly members, may take place in a manner that unjustifiably stands in the way of or render nugatory constitutional entitlements. I'm quoting directly from that paragraph. In that paragraph, in Mazibuko, Mosenege DCJ went on to hold that the entitlements to which we submit the independent candidates, as well as the electorate are entitled to, are not, open quote, available at the whim or discretion of the majority or the minority members serving on the parliamentary committees. The third in the trialogy is the judgment in Kham at paragraphs 86 and paragraph 87. This court, the judgment of Wallace A.J., held that the right in section 19.2 to free and fair election is a single requirement, and it entails freedom to participate in an electoral process, open quote, and the ability of the political parties and candidates, both aligned and non-aligned, to compete with one another on a relatively equal terms, so far as that can be achieved. To note in that judgment again, dealing specifically with the independent candidates at paragraph 87, and their ability to compete in elections, including elections in the National Assembly, the court held that the duty of the IEC is, open quote, to ensure a level playing field in which all participants can compete without undue hindrances or obstacles occasioned by, amongst other things, the way in which an election has been conducted. So, my lords or justices, if we accept, as we submit that it must be accepted as axiomatic, that the political constitution is essentially a numbers game, we submit that the regulation of numbers required for allocation of political office bearers in the National Assembly is not just a mere nuts and bolts, as one of the respondents have suggested in their heads. It strikes right at the heart of the voters' right to elect and to choose who will represent them in the public bodies like the National Assembly. And therefore, if a formula or formulae devised by Parliament to regulate political contestation is lopsided against the independent candidates and in favor of political parties, we submit that those measures constitute a pernicious abridgment of independent candidates' rights to a fair contestation in elections. And in the words of this court in Jafta, that regulation would render that right worthless. And in the words of Yakub J., it will render those rights empty and useless. And it will not constitute the leveling of the playing field amongst contestants in political arena. We understand there to be no disagreement between the parties and expect in this case that the 200 split that is envisaged in the Amendment Act would require independent candidates to achieve a quota substantially higher than a quota required of political parties. You'll see this, Chief Justice and Justices, in the joint report prepared by experts, particularly paragraph 17 of the joint report, where it's recorded without disagreement that at a 200-200 split, the quota for independents is substantially higher than the effective quota of parties. And if we look down the line in that document at page 781, paragraph 2, 19.2, and it is suggested the remedy of 350-50 has the additional benefit of reducing wasted votes cast in favor of independence and improved proportionality. In the section dealing with disagreements, these findings by the expert Atkins do not form part of the points of differences between the parties. So there lies the disparity between the independent candidates as well as when compared with political parties on the result or on the calculations and the agreements reached by the experts. So we say that there can hardly be any dispute in this case that there is that disparity that is created by this act as it stands, and that can hardly be fair. And once we are right in our submission that there is an unequal positions or inequality between the two groups of contestants, the independents on the one side and the political parties on the side, then we submit that there has been a fundamental breach of the right to fair, as pronounced by this court in the cases to which you have referred. That finding will throw this case completely into the arena or the territory of whether there is justification, therefore. And that's an inquiry that is dealt with under Section 36 of the Constitution. And that's the matter or the part of the argument which our learned friend Mr. Duval would address in due course, as well as the remedy. So we submit that we are good on the breach of fundamental rights on the basis that there's no equality of arms or leveling of playing fields as posited in the legislation which is impugned in these proceedings. And if we are right on that basis, and we are right that there is no justification for it, as the learned friend Mr. Duval will say, then the application should succeed.
We'll put questions to you after Mr. Duval has finished, so you will come back after he has finished.
Yes, all the questions you asked Mr. Duval.
You are happy for him to charge your fee rate.
No, thank you very much. Chief Justice, Justices, I prepared on the old immunity provision, so I have a 2-minute introduction, and then I'll make use of the other 10 or 12 or so minutes that are left. What I intend doing is to deal largely with the Atkins report and the 4 propositions that it stands for that we identify in our heads of argument, and then just briefly deal with what the Ling-Rosen report was about, and then afterwards, very briefly with remedy. Doesn't seem controversial. So, what is Atkins about? 3 of the 4 findings he makes are rather obvious, and it doesn't really require an expert even to reach those conclusions. Let's take the first one. What he's saying is that the effective quota for the independents will be much higher than those for the parties. And it's because the parties can get to the quota by 2 votes and the independents can only get there by 1. It has to lead to a discrepancy in the effective quota. It's obvious. The second equally obvious conclusion or finding that he makes is that if you reduce the compensatory seats from 200, with every seat that you reduce it down to 50, the difference or the discrepancy become less and less. Obvious has to. The third one, which is not as obvious, and where we really rely on his uncontested evidence, expert evidence of Atkins confirmed by 2 actuaries, this is the third one, is that there will not be significant risk of overhang if one reduces the compensatory seats from 200 to 50. And really, that's a fundamental issue, because as I will submit to you later, if one accepts that the 200-200 split results in proportionality overall, and you then start reducing the 200 compensatory seats and increase the regional seats up to 350, there is only one danger to proportionality, and that is the risk of overhang. That is the only thing that can go wrong. And I will show you, when we look at the Atkins report, how one can see that if one reaches 50 compensatory seats, there's an insignificant risk of a 1-seat overhang in certain circumstances, a particular permutation. But if one goes below 50 to 25 and 10, one then runs into a serious overhang risk of more than one seat, and more than one seat for the largest party, for instance, 2 seats or more, deviation from proportionality. And that is why we say in our heads, used, I think it's maybe a golfing term, but the sweet spot is the 350-50, because it's that spot which brings the equality of the vote much closer, fulfill that objective, why not, resulting in a risk of overhang and disturbing overall proportionality. That table B is of great importance to us. It's not challenged, but it's fundamental to our argument. Then the fourth, and add on really. It was illustrative at the time, but the fourth, the table C in the Atkins report, really just shows that if one reduces to 50 the compensatory seats, it doesn't disturb the internal, inter-party proportionality. That's not disturbed by that reduction either. It doesn't cause obvious anomalies in the inter-party proportionality, which is really what Ling and Rosen measured, except that they didn't take into account the independents as well. And that table C, there's nothing wrong with it, but it's not fundamental to our argument. It was included at the time, obviously because the parties are also respondents, and it was perhaps included there, or it was in fact included there to show to them that it's not going to affect their competition amongst each other. If I can now go, and unfortunately, I have to go to the report in some detail, and if I can take you to the report at page 49 of the papers. And Justices, Chief Justice, you will find the introduction at page 52, where he just explains what he's doing. And I've already explained to you, but paragraph 2 under the introduction at page 52, he says, this is the table A that will show later that the Act requires independent candidates to obtain substantially more votes to secure a seat than parties. Paragraph 3, the simple remedy is that the number of seats available for regional elections should be increased to 350 and compensatory seats down to 50. And then paragraph 5.
I'm sorry, just please repeat the pages.
Sorry, Chief Justice.
The original page
52, paragraph 3.
Is that the paginated 52?
I hope so. Yes.
Okay, thank you.
And then paragraph 5 there, and now we're talking about what is done in terms of testing the proposed remedy, that is limiting compensatory seats to 50. There was a detailed and comprehensive Monte Carlo simulation, that is repeated random sampling to obtain a numerical result, so it's within parameters, hundreds of thousands of simulations run. He says there are 9.6 million. With varying conditions to demonstrate that the proposed remedy does not disturb the constitutionally required proportionality of the National Assembly elections. And if one can then go to page 57, where he describes the electoral system, and how it works. I'm sure, Justices, you would have read Schedule 1A. Schedule 1A deals in item 5 with the regional elections. Item 6 is the compensatory elections. And then item 7 is what happened if an independent gets more than one seat and the parties list as insufficient names. And now there needs to be a forfeiture of a seat. So in simple terms, what item 5 says is the starting point is the seats allocated to the regions. In the past, they vary from 5 allocated to the Northern Cape to 48 in Gauteng. That's the starting point. One then takes for each regional election is proportional in its own terms. So one takes the total vote in the region divided by the seats, 5 in the case of the Northern Cape, plus 1 seat to get to the regional quota. And then the parties are allocated seats depending on how many times their vote justifies the regional quota. After that, if all the seats are not allocated, one then has the largest remainder method that is used. Largest remainder then gets those seats. That is item 5. So one ends then up with all 200 regional seats being allocated according to the provinces or regions. And it's not fundamental to the argument, but that election is already proportionally representative for each region because of the droop that gets used and the larger remainder method. One then goes to item 6, which is the compensatory seats. And unlike in the past, one now has a compensatory ballot. On that ballot, the independents are excluded, of course. That's why we're here. And how it then works is one takes the total number of seats in Parliament, that's 400. One deducts any seats that the independents won, that's minus 400 minus the independent seats. And one then divides the total vote for the parties for both regional and compensatory plus 1 with that in order to reach the quota. And I'll get back to that because that's item 6A, which is a tricky clause to read in a way. If I may now take you back to the Atkins report, and at page 61, he describes the electoral system, and I must just say at this point that there are no interpretive issues. We in the IEC understand the mechanism in the same way. There's no different interpretations that can lead to different results. If I can then move on to this discrepancy in the quality of the vote, and at page 61, he deals with this topic. At page 61, he deals with the election that took place in 2019. And this was the actual regional quotas in 2019 there at paragraph 38. And the court will see for each province the regional quota is different. And at the bottom, the regional quota average, the weighted average would be 83,511. Now let's look at the parties, what their quota would be, and you would find that at paragraph 42. In the 2014, the comparator being the 2019 elections, the quota is 43,485 for the parties. And again, as I said, it is obvious that the quota for the parties in that election would be much lower than the regional quota was. So if one then just argue logically, the quota for the independents would be something like paragraph 38, and the quota for the parties would be something like paragraph 42. But it goes on over the page to illustrate this now, and perhaps paragraph 47 isn't introduced enough over the page, page 63, paragraph 47. This is how he now applies item 6A of Schedule 1A to the new system. And it depends on support for independence being either at 2% or 8%. That PR vote number and regional votes, I know I'm repeating myself, but what this is illustrating here is an application of item 6A in terms of the new system to the 2019 results. And the court will see in 2019, 17,437,379 people voted. Let's just make it 17.4 million. And if one then takes the independent support that you've got to subtract from that in order to make the calculation required by 6A, so it's 17.4 minus the 2% of the independents give you 17.088. One takes the total of that, and you have to take into account the independent seats of 2. So it's then 398 plus 1, which one then use, and you divide the 34.5 million with 399 effectively to get to that quota of 86,532. Now, what the respondents, or some of them, are arguing is, if you look at that quota of 86,532 and you compare this to the regional quotas at paragraph 53, or the ones that we've just gone through, there isn't much of a difference. What's our problem? The problem is, of course, they get to the 86,532. They get to that quota by 2 votes. That's how they get there. The independents in the 53, that regional quota's there, they've got to get there with 1 single vote. Now, what Atkins is doing now at this point, he says, okay, that is the Schedule 6A quota for the parties, but I've got to transform this into a 1-vote quota. What would be the equivalent 1-vote quota? And he goes on at paragraph 48 to say, the easiest to get to a 1-vote quota would be to simply divide the 86,532 by 2. Then you get to equivalent 1 vote. But he says that is not ideal because that's in favor of our argument. Let's take the higher number, the PR votes number, the 17.4.
That is the end of the 30 minutes.
Yes. The 17.4. Let's take that number and you'll, sorry, I can't
Once
say
is
anything.
the end is the end.
Yes.
Yeah. We'll ask Mr. Madonsela to come back and we'll put questions to him first, and after that you can come back. I was not sure, Mr. Madonsela, at the beginning of your address, whether what you were saying amounted to saying that there mustn't be a division at all between the 200 seats in respect of which independents are able to contest and people are able to vote for independence, and the 200 that in respect of which the voters vote for political parties. But looking at the affidavits, I would have thought, understood that there is an acceptance that there has to be some division. The argument, the dispute is whether it should be 200, 200 or 350 and 50.
Yes,
Am I right?
you are right, Chief Justice. The division of 200, 200, the differentiation, in other words, the separation of votes and the two-tier process of calculating vote, we accept that at some point it must be done in order to achieve what is called inter-party proportion.
Yes.
At that, to deal with fractions.
Yeah, no, that's fine. Now, Parliament has said 200, 200. You say 350, 50, is that right?
Yes.
Now, different people might have divided the seats differently. Does it become wrong just because you prefer a different division? Is there a constitutional right, a constitutional provision that's infringed just because you prefer a different division of the seats to the division that Parliament has chosen?
It is wrong. It depends what is the purpose for doing that.
Yeah.
The first to understand the purpose is to achieve what has been called in the papers overall proportionality. That's the purpose of having the second tier where you divide 200 and 200, so that you can say, well, there are seats that are to which certain parties or independents are entitled to, but they are not available because of the capping of the seats in the National Assembly. So that overload or that remainder or excess has to be rounded up proportionally up amongst parties represented. That principle is accepted. It has to happen. But the issue here is, why are you doing that as the IEC? We are doing that in order to achieve, the papers say, and I think there's agreement about this in the papers. We are doing this in order to achieve the Section 46(1)(d) reasons, what is called proportionality in general. And everybody seems to accept that in every situation we can never be able to have strict proportionality. That's why even the language of the Constitution talks about proportionality in general terms, because we can never, it's near proportionality. So if that is the purpose, it is wrong to do so in a manner that is lopsided in favor of political parties and not achieve parity.
Well, you have just made the point that there isn't any perfect proportionality. There is no perfect proportionality. So obviously that also means you might come up with a division that achieves a certain amount of proportionality, and Parliament comes up with a division that achieves a certain amount of proportionality. Somebody else could come up with another one that achieves a certain proportionality.
Yes.
Where do you draw the line to say, if you get this kind of proportionality, it's unconstitutional, but if you get that kind of proportionality, it's constitutional?
You draw a line where a proportionality figure that is utilized has an effect of placing one of the groups of the contestants at a serious disadvantage in the political contestation. And that point is reached in this case when 200-200 split is chosen over a higher threshold or a higher division number, which is 350, or it could be 360 or 355. Once you go up because the mathematics, I did say I'm not an expert in mathematics. In mathematics, the higher you divide the number by, the lower the threshold. So if you decrease the threshold by increasing the number by which you divide, you increase the contestation, the political contestation, you level the playing field in the language of this court by ensuring that both parties, both groups in this case, political parties as well as independents, operate on a par or have an equal chance to compete.
Do you accept the proposition that is made by at least some of the respondents that individual candidates can't assist with proportionality? It's only the political parties. Do you accept that proposition?
We accept that's a reality, but that is precisely the reason why you should then devise a formula that puts them on the same competitive basis as political parties when you formulate a formula, because they have got that disadvantage.
Well, if you look at the individuals and the fact that they won't assist with proportionality, immediately that tells you that the two, namely political parties and individual candidates, are not the same. Their contribution to an electoral system that is proportional in general is not going to be the same, because the individuals can't contribute there.
Yes.
So you have to accept that the two can't be treated the same, isn't it?
But what we are doing,
Because they are not the same.
they are not the same. You can't treat them the same. But what you are doing when you allow that situation to occur, you are weakening the voice of the people who have voted them. Because when they go on the second round, the votes they amassed at the regional level are wasted.
Yeah, but even with political parties, there is, as a matter of principle, even with political parties, there will be votes that are wasted in your language, because if they have achieved a certain number of votes, but they don't reach a certain quota to get another seat, then you have wasted votes in that sense.
Yeah.
Both for the individuals and for political parties, that would happen.
Yes, you may waste their votes, but you are not taking away their chance to compete, because they still remain in the competition.
And what is
as a result of the proportional?
And whose right do you say this division by Parliament infringes? Which right and whose right is infringed?
It's the right of the voters, which is in Section 19, and to elect a representative, and the right of the electors to be elected and stand for office, because that right is attenuated.
But isn't the position that currently, following the judgment of this court in a New Nation movement, what Parliament was required to do, or what at least Parliament has to do, is to achieve a mix where there is proportional, there are political parties and there are individuals. And if that is the case, voters are able to vote both in respect of the 200 seats where it's only individuals, and in respect of the 200 seats where it's political parties. So the actual voters are able to vote for 400 seats.
Except that the vote of the voters, those who vote for independence, their vote is count less in the overall.
But if they choose to vote only for, in regard to the 200 seats which are for individuals, and they don't vote in regard to the 200 which are for political parties, that's their choice. But if they want to influence and vote in regard to all 400, they can vote for the 200 where it's individuals, and they can vote for political parties for the other 200.
No, the limitation in the split is that it weakens the voice. No matter how much they say, they'll always never be able to reach half of the nation of the national party, and that is not competing with political parties on par. That is our complaint. That the fields are not leveled when you compare independents to political parties, because what political parties in this legislation say, because it's essentially political parties represented in parliament to pass the legislation, they say, you independents, if you want to come and run the elections, go through the eye of the needle. But we politicians must go through the open doors. That is intrinsically unfair, we say, because they are not given a fair competition to compete at the same level and with the same potential as political parties would if the 350 system was to be utilized.
I'm just looking. Justice Mhlantla has questions for you.
Thank you, CJ. I hear you on the issue of competition. Your concern, if I understand you, is that the independent candidates have to compete with the parties in respect of the 200 under the regional sector. Then the parties, again, they also have the 200 where they would be competing. But that's the one issue of competition. What about the issue of the risk of overhang, which has been raised by the respondent,
yes,
and which, if I'm correct, Mr. Atkins also alludes to that. He does say the 350-50 split, there is a marginal risk of overhang. He doesn't come up with a proposal on how to deal with that, except to say Parliament should have dealt with it. But you, as the applicant, you are here. I think you have to at least explain to us how do we deal with that. Because if we say, yes, we agree with you on the issue of competition, what are the consequences of that? How do we deal with the concern that has been raised of the issue, the risk of overhang, and the effect of that on the results of the elections?
Thank you, Justice Mhlantla. Thank you for that question. I meant to address it earlier, but my time was up. The issue of overhang is an issue. No one we accept that there is a remote, even though remote prospect it is in relation to minor political parties, in relation to one seat. It's potentially there. We accept there is that potential, but that issue is more an issue of the remedy rather than the issue of fundamental rights. I would like to draw this distinction because it's important to our argument. If you are going to pit fundamental rights which are attenuated by 200 and 200 split against the aspiration to achieve proportional representation in Parliament under Section 46D, it is unavailing because we are the proportional representation principle in Section 46D is not a fundamental right. It is not a value of the Constitution. So it cannot be utilized as a sacrificial altar on which fundamental rights can be sacrificed. You have to then pit that aspiration, the aspiration to achieve general proportionality against the fact that you are depriving a number of voters a fundamental right in the Bill of Rights. And this has been said in a case which I wanted to refer to earlier. It's UDM case, it's paragraph 27 and paragraph 28, where the court said that it was a deliberate choice by our constitutional drafters to make it distinct, not to make proportional representation a fundamental value of the Constitution and part of the fundamental rights, although it was once in the general principles, but it never saw its way into the final Constitution. You'll see that at paragraph 27 of the 28 rather, where the court said significantly, however, section 1D of the Constitution incorporates all provisions in the constitutional principles. It had been contemplated that proportional representation should be one of the founding values, but it is difficult to understand why those were omitted from Section 1D. Textually, therefore, it means it has excluded. So it's not part of the fundamental values of the Constitution. It's not part of the fundamental rights. So you're pitting two things. You're sacrificing right at the altar of achieving what the Constitution does not even envisage should be a strict proportionality. It requires that IEC should thrive, or Parliament should thrive, to have that generalized version of proportional representation. So when overhang is a byproduct of an attempt to achieve general proportionality, it is not even a constitutional principle. Why should it trump fundamental rights? That is our argument here. So when it occurs, it's a question of a remedy. It can be, it's solvable. It's solvable. We know this because recently, this very Parliament dealt with the issue of an overhang and excess seats in relation to local government. It promulgated on the 1st of November 2021 the amendment to the Local Government Structures Act, and in item 1, it's Schedule 1, item D of the Schedule to that Act, it gave an elaborate way in which you can deal with the problem of overhang and excess votes, and it created a formula there. So it is a question, it is a concern, my lady. It was up to Parliament to deal with it when the representations were made to it, to deal with the problem and find a solution, as it has done in local government. It did not do so. So it cannot be a defense to say, no, we're going to have a problem of overhang when it is within the remit of Parliament to solve it.
So what you're saying, we must ignore that concern if we are with you on this point?
No, we should not ignore that concern. What the court what is open to the court is under its general discretion to formulate a remedy in the interregnum between now and the elections that will deal with the problem of overhang in a way that's been dealt with in local government, but then give it to Parliament to go and resolve it. Because Parliament can solve it. It's solvable. And my little friend, Mr. Deval, is going to expand on it because it is his field more than I. But I've attempted to say one or two things about it.
Thank you.
Justice Colopen.
Thank you, Mr. Malancello. In response to questions put to you by the Chief Justice, you tried to explain the regional versus the national. As I understand item 1 of Schedule 1A, independent candidates will only contest the regional tier of elections, correct?
Yes.
And their names would not be on the list of the national tier, correct? The national tier would be political parties.
Yeah,
For the 200 compensatory seats. So at that level, the voters don't have a choice, as it were, at the national level. They have to choose a political party. They cannot choose an independent candidate in respect of the 200 seats, correct?
Yes. Yes, but Justice, you're right.
you have a choice.
You don't have a choice.
No, you have a choice. But equally, independent candidates are restricted to making themselves available for election only on the regional tier, correct? So at that level, there's a limitation in terms of where an independent candidate may seek election. It would be on the regional tier only. And voters also are limited in terms of who they may wish to vote for. A voter who wishes to vote for an independent candidate at the national tier may not do so, because an independent candidate doesn't contest the elections. Is that a correct understanding then of?
That is how we understand it. I may be correct. It may very well be a calculation exercise.
Okay.
Having votes having been made. But the effect is the same. The effect is that independent candidates are never going to be able to run on their own ticket for what is called PR representation to the national on the second segment, because that, as the Parliament says and the IEC says, is left for what is called compensatory seats to do inter-party proportionality. So they have no contest there.
Okay. There are probably other questions, so let me just have one more question, and that is on the question of proportionality. It would seem that all the parties accept that perfect proportionality is unattainable, and that disproportionality is inherent in the system. The question is how you manage that. Now, it seems that at one level, independent candidates run the risk, certainly at some level, of losing a seat. That's where they may have garnered enough votes in a region to warrant 2 seats mathematically, but because they can only hold 1, they lose the seat and they lose the votes that go with that loss. But they could also lose it if they win elections in more than 1 province, because then they can only hold 1 seat, so they would lose that as well. So that loss in itself distorts proportionality, because ultimately those votes are not reflected in the seat allocation, because that's how the system works and that's the choice they make.
Yes.
And it would seem that arising out of that, the system works better for political parties, and maybe understandably so and legitimately so, because if you're organized, then you can do better in an election. How does one deal with that disproportionality in the context of the disproportionality that overhang may bring? I just ask, have you got any views on that? That you're trying to strive for proportionality, and on the one hand you have disproportionality that may operate against the candidates, and on the other hand you have disproportionality that may operate in their favor. So is it a case of 6 of one and half a dozen of the other? What you lose on the swings, you gain on the roundabouts. I don't know. Do you have a view on that?
Yeah, the answer is to remove the debate from the contestants and look at the problem from the perspective of people who voted, who wanted their who wanted their people to hold office. If their votes for independence in this particular scenario are discarded irredeemably, because they can never be counted in the second round of compensatory seats, those votes and that voice of the people is forever lost. No matter how many numbers you get as an independent candidate, you stand no chance whatsoever. Just in order to sacrifice that voice, that expression of will of the people, that democratic right, at the expense of trying to strike the balance on some one hangover or overhang in relation to a distant possibility. That's the disproportionality, actually.
Justice Rogers.
I have a question for Mr. Duval. I'm not sure if you wish to finish Mr. Madonsela first.
I assume I've answered all the questions.
Let's finish with Mr. Madonsela first. Okay, thank you. Justice Theron.
Thank you, Chief Justice. Mr. Madonsela, you argue that the 200-200 split is irrational because there's no justification for the split other than the improper purpose of undermining the prospects of independent candidates getting elected. I'm not sure there is sufficient evidence for you to make such an argument. Perhaps let me be specific. On what basis do you suggest that the 200-200 split creates this improper purpose?
Justice Theron, I'm not sure whether I understand the question. If the question is whether there is evidence on the record, our position is that for Parliament to justify the 200 and 200 split, because the 200 or the upper limit of division, which was going to introduce a upper or lower threshold, was introduced in Parliament during participatory process. And it's clear from the documents which were exchanged, and in particular an opinion by one eminent senior counsel who gave opinion to Parliament, that there was a proposal to Parliament for an increased split between 350 or 375% split. But Parliament did not do so. And it's for Parliament to justify their own decision. It's not for us to give evidence of why the split was more realistic in order to achieve proportionality. But I mean, Mr. Duval is going to address the court on that particular aspect of what was done in relation to that, because it was done, on my recollection, and there is a record of representations made by Mr. Atkins to Parliament on that very issue. And it's for Parliament which did, the answer to it was that Parliament ignored it and did not address it completely. And we have this problem which we have now. I think at the time the idea was to introduce 300 to 100 splits. There were a number of permutations were given to Parliament. Parliament decided to choose one. So it is in the record, Lord. I can find it, my lady, if I have time. Mr. Deval certainly will find it. But it is on the record.
Yes, I had understood the applicant's case to be that the only justification that's being advanced for the 200-200 split is to achieve this improper purpose, and that was the reason for my question.
Which improper purpose, Justice Theron?
Of undermining the prospects of independent candidates getting elected. I had understood that was part of the argument that the applicants was advancing.
Well, Mr. Deval is going to address you on that.
Yes, very well. Now, well then, maybe Mr. Deval is the one to address the next question as to what the response of the applicants would be to the submissions made by the respondents, that the 200-200 split serves a dual purpose, to achieve proportional representation and to avoid the risk of overhang, while they do accept that there is some overhang.
Yes, but the reason has been stated, but you achieve proportionality even at 350.
Yes. Now, because independent candidates can only hold one seat, is it not so that the inclusion of independent candidates, and this is also what my brother Justice Colopin was talking to you about, carries the risk that proportional representation in the National Assembly will be distorted?
If you have independent candidates only. Can you please repeat the question, Justice?
Okay, let me
what will distort?
Let me put the question a different way. Isn't it so that the 200-200 split, although perhaps the applicants might disagree with the exact ratio of the split, doesn't it serve a legitimate government purpose?
The purpose which has been advanced for 200-200 split is to achieve proportionality in general. And that general proportionality is achievable, we say, at every level. If it's 200, you achieve proportionality. At 350, you achieve proportionality. The problem, of course, in relation to 350 is an overhang. And we say that problem is solvable. Parliament just did not apply itself to it.
Let's deal with the overhang, Mr. Madonsela. Even on 350-50 split, there is a risk of an overhang. What are the consequences of a 15% risk of overhang?
It's a possibility.
What's the consequences of a 15% risk of overhang?
Well, there is a risk that the elections may not be declared. That's a risk, inherent risk. But we say it's a remote risk, but it's not a risk that cannot be solved if Parliament applies its mind properly to it. The problem here...
There's a risk, as I understand it, on the 200-200 split. There's also a risk on the 350-50 split. Is that right? There's a risk of overhang.
No, but the risk of overhang has only been detected on the permutations done on the 350-50 split. On the 200, there is no indicated risk of overhang. Not because it will not occur, but because the permutations or alterations which were undertaken did not get that far. But it's always a possibility to have overhang because of fractions. We can never know the numbers of voters. And overhang occurs because we can't allocate half a seat because there are always the fractions. And fractions are overhangs and excesses occur because you want to round off and you want to avoid excess seats. That's why we have an overhang. But it's not an insurmountable problem. And Parliament tells us why they have not dealt with it in their papers. They say in their papers, no, we decided we're going to take a shortcut approach because we wanted a route that was going to be minimalist, that was not going to require Parliament to have an extensive amendment of the Act. And partly because it was utilized during the 1999 election. But those are the reasons, that's the rationale. But when court said to them, go and find a proper solution, they should have done a proper job at it and not take shortcuts. They had 2 or 3 years to do it. They came to this court time and again to ask for an amendment. If they had engaged properly with the 300 or 350 split, they would have found the answer. And we say an answer has already been found in the context of the local government. And it can be fashioned by this court as a remedy whilst Parliament is still exercising that exercise.
Mr. Madonsela, as I understand the applicant's argument, and please correct me if I'm wrong, the applicant is not challenging the existence of the compensatory seats, nor the two-tier system. Yet the applicant suggests that the 200-200 split arbitrarily differentiates between independent candidates and political parties. I have some difficulty following that argument.
It's arbitrary, my lady, we submit. In the context that
But the
arbitrariness...
applicant's not challenging the compensatory seats nor the two-tier system.
No, we're challenging the split, the 200-200 split versus 350 split. We say the 200 split is arbitrary because it does not give a justification why you can't utilize 350 and resolve problems of overhead. And there is no justification for it because Parliament did not engage with that argument.
Does the applicant accept that there's no differentiation between independent candidates and political parties in respect of regional seats?
Yes.
And what do you make of the submission by the respondents that the allocation of seats to independent candidates at the regional tier is not affected by the quota for the allocation of compensatory seats?
No, the quota, the quota for the regional seat remains the same for all the parties. The problem here is that when they do the second calculation on the proportionality or compensatory seat, independents are excluded completely. So that must overall reduce the numbers of the votes or the seats for the independents, which political parties will be entitled to on the second round. It means that the independents have no chance to compete on the second tier of the calculation.
Does the differentiation between independent candidates and political parties not go to the inherent nature of the two different tiers and their functions? The two tiers serve different purposes. The regional tier serves to ensure regional representation in the lawmaking process, whereas the compensatory tier serves to ensure that the outcome is proportional in general.
There is an inherent difference between independents because independents can always get a seat no matter how many votes they get. That is a given. But that is, in our submission, precisely the reason why when accommodation for independents is to be undertaken by Parliament as this court directed, that factor had to be taken into account. It was not because Parliament opted for an option that was lopsided in favor of the political parties.
Now, Mr. Madonsela, what are your submissions on the fact that Parliament is afforded a wide discretion as to the manner in which to conduct the electoral system for this country? And even though the applicant may prefer a 350-50 split, because Parliament has chosen a system that is not the first preference of the applicant, does that necessarily mean that the 200-200 split does not meet constitutional muster?
Our submission on that score is that Parliament does have discretion, but that discretion cannot denude fundamental rights in the Constitution. It cannot be a discretion that leans towards making the right of independence worthless.
I'm not sure we can go so far as to say you make the right worthless. It may disadvantage independence in a certain way, but this is the core of my question. Does it render the system chosen by Parliament unconstitutional?
We say
the fact that independence might be disadvantaged.
We say, Justice Taron, that on that score, that the differentiation does not place independence at par with political parties.
Yes,
And it does-
let's accept, Mr. Madonsela, for the purpose of this debate, that there might be a disadvantage. Does that disadvantage on its own render the system chosen by Parliament unconstitutional?
Yes, if it is arbitrary, Milady, then it is unconstitutional because it fails to meet the minimum test of rationality. But secondly, if it is unconstitutional because it breaches the fundamental rights, it has to be justified under Section 33, and there is no justification for it in this case.
Is there enough before this court for the court to find that it's arbitrary?
Sorry?
Is there enough before this court for this court to find that it's arbitrary? That,
Well,
the system chosen by Parliament is arbitrary?
Yes, justice arbitrariness is a concept which this court has formulated in the case of Minister of Constitutional Development versus South African Restructuring and Insolvency Practitioners Association at paragraph 49 and 50 to 55 of that judgment, where the court says arbitrariness is failure to justify reasons for the decision
Yes.
you have taken. You have two choices. Parliament was given a number of choices. One of them was to utilize 350-50. They did not anywhere in the record, except in the papers now when the answer, give an explanation why they did not prepare or justify a deviation from 350 and 200 split. That's arbitrary.
The applicant relies heavily on foreign law, in particular the United States, Australia and Canada. Now, bearing in mind that our electoral system is quite different from those jurisdictions, how does relying on those systems advance the applicant's case in this matter?
We rely on international law, firstly, because it is an interpretative injunction in Section 39(1)(c) or 1(b).
Yes,
of the
now I understand
Constitution.
that, but we need to compare similar systems. What can we benefit from what you've put before us, in particular from the United States, from Australia and Canada, when the electoral systems are so different from our system, Mr. Madonsela?
Well, what we glean from foreign jurisdiction is that courts in foreign jurisdiction accord parity of votes and equality of votes. And that is a principle that shines through even at international law, and I refer in this particular paragraph 45 of our heads, where we refer to Article 45 of the United Human Rights Commission Committee comments on the ICC-IPR, which is a covenant which South Africa is a party to, where states are required to grant votes of electors equal vote with other votes given for political parties. That is the level at which we pitch it. And we say that under the interpretative injunction to consider international law and foreign jurisdiction to bolster the argument that votes must be given equality, whether they're given for independents or political parties, that those authorities stand as persuasive authority. Of course, within the margin of appreciation or subsidiarity principle.
Yes. My last area of concern is that of remedy, Mr. Madonsela.
Sorry, Madidi?
My last area of concern is that of remedy.
Remedy.
If we with the applicant and the provisions are constitutional, if this court was to substitute the 200-200 split with the 350-50 split that you propose, would this court not be breaching separation of powers?
Well, the remedy, the court has got wide powers to grant a remedy that is effective.
Yes, I've asked a specific question now, Mr. Madonsela.
It won't be a breach of separation of powers because the courts are vindicating the rights. Firstly. Secondly, they're giving them an effective remedy before the elections. Because what would be the point of succeeding in court? That the applicant succeeded in new movement and get a no effective remedy when the elections are around the corner.
The court would basically be imposing an electoral system on the country.
It will not be doing so, my lady. If the court grounds its judgment on the fact that there's been a diminution of rights of citizens in Section 19, it will be giving effect to those rights in a way possible. And the way that has been identified by the applicant is the 350. But we are open to, the court has got wide discretion.
Are we able to send the Act back to Parliament with the suspension of declaration of invalidity? And what would that mean for the national elections that are due to be held in 2024?
If you were to suspend the order, it will mean that the elections will go on the basis of what is now in the legislation. But that will be a no effective remedy to independence in this coming election. So the remedy would have, the victory would have been hollow, because there would have been no effective remedy that will take place on the ground when the elections are taking place next year, because of the timetables problems that have been highlighted by the ICC in its affidavit.
Thank you, Mr. Madonsela. Thank you, Chief Justice.
Justice Matopo.
Mr. Madonsela, just a few questions to put to you. Before the amendment came into effect, there were various consultations conducted by the minister and all other stakeholders. And public participation was also called for. And one cannot, looking at the history and the chronology of this, and say that the decision was taken rashly. I don't want to use the word arbitrarily. There was thorough and proper consultation, and the system that you are proposing, the 350 and 50 split, was also considered. The 200 split, 200 and 200 split was also considered, and expertise was sought, and Parliament in its wisdom decided that this is a system that is acceptable. Now my question to you is, Parliament with that expertise, having undergone that exercise, are we as a court in a better position to second guess what has gone through the entire serious and properly investigative processes? What can the court do? And how far can we go? The second question is, isn't this a risk that the independent candidates are taking? We know that whatever happens, the independent candidates are entitled only to one vote, and vis-a-vis the political parties who may have more votes. In practical terms, right? What practical effect would the independent candidates achieve by the whole exercise? Because whether they win or lose, their victory will redound to one vote. And you can well imagine, we can have independent candidates campaigning and throughout and the length and breadth of the country, just for one vote. But is that what they seek? I would have understood if you had challenged the independence entitlement to one vote, to say, but we can do whatever, we can do the same as political parties. But what we will get is just one vote. Oh, sorry, one seat, sorry.
Yes.
I've just been corrected, sorry, yeah. Just get one seat.
No, I understood. Yes.
You understood the question?
I understood.
That worries me.
Yes. No, can I just start with the second one?
Please.
Independent candidates, one seat for them of the 400 seats is a chance for them to lead this country. Is a chance for them to influence decisions in the political body. If they, let's say there are 9 of them or 20 of them in provinces, get a seat and a chance to be in the National Assembly, all of them, outside of political parties, they have a chance to influence decisions. It's about the voice they want to exert in that body. No matter how minimal it is still a voice. So, practically, independent candidates want a realistic chance to participate in politics in this country. And that is the chance that the Constitution grants them. And Parliament cannot take it away from them.
I would have understood you if you would have had complaints with that one seat. Because basically it's a hope that if we are successful in our elections, we hope that we would be able to influence the debate in Parliament or in provincial legislatures and sway the vote to a particular course of action. So basically all that you're asking us to do is restore the hope and faith of independent candidates. And that, to do that exercise, we have to weigh what Parliament has sought to do to try and meet the independent candidates following the judgment of this court, which allows them the right to participate in the elections.
Just a matter of independent candidates' hope is not different from the hope of politicians, political parties. They share the same hope that political parties. Political parties in this country hope that people will take them back into power. And the court cannot disgorge the hope that independents have on the basis that it's just a mere hope. On the first question of how far can the court do when there's been thorough participation, our submission in this case is that there was public participation, but there is no evidence on the record, which, unless if the respondents pointed out to us, where there was serious engagement with the issue of 350 votes by Parliament. It's being asserted only now in affidavits. There are documents which were issued by advisory committees, there are all sorts of reports given to them. What was given to them, what is in this record, is a statement that this issue of 350 split was raised, but it's a policy decision. And as a result, Justice Matopo, as a result, when you search the record, you will see that experts which put up their reports here, in this case on behalf of the IEC, don't actually deal with this issue of 350 at all. That's why in their joint reports they could not even challenge Atkins' report, because they did not even undertake that exercise. All that they did was to compare the system that occurred in 2019 with the system that is now preferred by the Amendment Act. But there was never any engagement with the 350 split. So that makes it irrational, that makes it arbitrary, and for those reasons we say that we should succeed. Justice Matt,
I must raise this because it worries me, and I don't want to leave you well on your feet and when these things are concerning me. Thinking aloud, I'm just wondering why the independent candidates, or whether the independent candidates could have launched a different frontal attack to this bill, short of what we have now. Could it do anything differently, or its hands were hamstrung?
Well, I'm not in their mind, but thinking aloud, you pick up your battles as and when you come. There is an indication in the papers. Mr. Duval will probably find it. There's an indication of Duval that this is just one of the challenges. Another challenge might be coming in the future on the entire system, on the entire rubric of the system, whether it is sufficient to accommodate independent candidates. But here we have a problem now. The elections are next year. We're going to pick up the battles that we want to fight and chow as much as we can and bite as much as we can chow. We are in this territory now to deal with just granting independent candidates on this challenge an equal chance with political parties. Another challenge can come in the future, and I suspect it will certainly come. But that is not the reason, my Lord, that we should be deprived of the remedy now on what we have asked for, because it's either we have made out a case for it or we have not made out a case for it. Chief Justice, I think Mr. Devan is urging to stand up.
Mr. Madonsela, there is still one colleague who has a question for you.
Mr. Madonsela,
Justice
I
Tipas.
just have, thank you, Chief Justice. I just have one question for you, Mr. Madon, two questions for you, Mr. Madonsela. As I understand your argument, does the applicant accept that on the 200-200 split, that proportional representation in general, as contemplated in Section 46(1)(d) of the Constitution, is achieved? Do the applicants accept that?
It is achieved. 200 and 200 split achieve what is called inter-party proportionality.
The question is, does it achieve proportionality in general? That's the question.
It achieves inter-party proportionality in general amongst the parties them only, but excluding independents on this formulation.
Can I ask you again, because I need to understand your argument. Does it achieve proportional representation in general as contemplated in Section 46? It's a yes or no answer, Mr. Madonsela. Because as I understand your argument, you say that it does achieve, in response to my colleague Justice Theron, you said that it does achieve proportionality in general, but the arbitrariness lies there in the that it has not taken into account the 350-50 split. Now, I just want to understand clearly what your argument is.
General proportionality is always achievable on all the numbers. But the question is whether it's proportionality as representative proportionality as required by Section 46(1)(d). We say that is not achieved. But proportionality in general, mathematical proportionality, yes, it's achieved, because there is some form of proportionality.
So let me just understand your answer. You're saying that proportionality as contemplated in Section 46 is not achieved?
It's not achieved.
By the 200-200 split?
Yes, because it excludes independence on this formulation.
Thank you, Mr. Madonsela.
Oh, well, I understood your answer differently.
No, Chief Justice,
I understood your answer to be saying you accept that the 200-200 split achieves the proportionality contemplated in Section 46(1)(d), but you have something to say, but that you are accepting that.
Chief Justice, maybe I should maybe clarify. Proportionality is achieved
and
by
to make
200.
it clear, proportionality as contemplated in Section 46(1).
No, it's
we're not talking about any proportionality. We're talking about that proportionality which the Constitution contemplates in Section 46(1)(d).
Yes.
That's the one we are asking about.
The 200-200 split does not achieve proportionality in general, inclusive of independent candidates. It achieves what is called, and they've called it in their papers, inter-party proportionality. Now, the generalized version of proportionality, if it excludes independent candidates, then of course it is. But if it has to include them, then of course it's not.
Well, the proportionality referred to in 46(1)(d) is not qualified in any terms, isn't it?
It's in generalized terms.
Yes.
I think, Chief Justice, there is acceptance here by all experts, and I think all parties do accept that you can never numerically achieve what is called strict proportionality, because
perfect proportionality. Section 46(1)(d), I think everybody accepts, doesn't contemplate perfect, I think. It's just in general.
In general.
Yeah, so the question that was put to you by Justice Skippers relates to that proportionality that's contemplated by the Constitution, not any other proportionality, because there may be different versions of proportionalities. He's talking about that one that's contemplated by the Constitution, which on the face of it, is not qualified other than in general.
Well, on the papers that we have here, we understand the respondent's case to be that we are achieving inter-party proportionality.
Okay, thank you, Mr.
Whether
Madoza.
that is sufficient for constitutional compliance is something that I think Mr. Duval will deal with in a moment.
Thank you. We have gone past the tea break, but I think maybe let's finish with Mr. Duval, if possible. Then we can take the tea break after that. Thank you, Mr. Duval. Justice Rogers had a question for you.
Yes, Mr. Duval, just to understand the essence of your case, for the 200 regional seats which both independents and political parties can contest for.
Sorry, Justice?
For the 200 regional seats for which both independent candidates and political parties can contest, they each get a vote from one voter.
Yes.
Let us very roughly say that that results in an average quota across the country of 80,000 in order to obtain one of the 200 seats. And political parties have the same limitation there as independent candidates. But for the other 200 seats, the compensatory seats, the votes that are taken into account there are the votes cast for the political parties for the regional seats and for the compensatory seats. So they get effectively one vote counts for two. So that, let us say, roughly speaking, the political parties can contest for half of the seats in the National Assembly by just getting, say, 42,000 votes from multiplied by two, because they count it on two ballots. Whereas the independent candidates can only contest for the other half and have to get 80,000 votes.
Yes, correct.
That's the essential unfairness and differential treatment which you seek to avoid by proposing the 350-50 split.
Yes.
And the main thing that is put up against that is the risk of overhang, which is just another way of saying that there is a risk that you won't achieve proportional representation in general as required by the Constitution. Would I understand the position correctly that a risk of an overhang of one seat means that when you come to the compensatory seats, ideally you would want one more seat than is in fact available in order to achieve proportionality amongst the political parties? That's an overhang of one seat. So either the largest party or a major party or a minor party might not get one seat, which if it were available would create, let us call it, practically perfect proportionality.
Yes.
Now, if you can turn to the Atkins report, where he does the analysis based on the 2019 election results at page 73.
Yes.
Page, if my pagination is correct, he's got table B there, which is pages 73 and 74, and that analyzes the position for the probabilities of an overhang for the main parties, for the minor parties, and for the largest party. Right. Now, if one takes your scenario or your proposed solution of 50 compensatory seats, you will see that at a risk of, at a level of support for independence of 1%, there is a 2% risk of an overhang of one seat.
Yes, Justice, there's just one qualification, that's 2% risk at 1% in respect of a main party.
Yes. So if independents garner 1% on average across the country, and one is looking just at the main parties, there's a 2% risk that you would have needed an extra one seat to one of the main parties to restore perfect proportionality.
Yes.
In other words, if you ran this national election 100 times, 98 times you'd get perfect proportionality, but twice you'd be missing one seat.
Yeah.
And if you run your eye down the 50...
But that's for one of the main parties, not all of the main parties,
yes,
for one
of the main parties would have had to get one seat to restore perfect...
In that particular permutation, yes.
The 2 out of 100, yes. And if you run your eye down the 50 compensatory seat scenario, as independent candidate support increases up to 10%, the risk of the overhang reduces. So the overhang risk is at its greatest with 1% support. It's at its least with 10% independent candidate support, because there the risk of a major party losing out is 0.03%.
Yes.
And over the page for minor parties, we'll see that at 1% for independent support, there's a risk of 6.8% of a one-seat overhang, but a zero risk for anything else.
For more than one?
Yes. And for the largest party in the bottom table, you will see that at 1% support for independent candidates, there's no risk of an overhang on any scenario.
Yes.
So just taking those figures, one could ask the question, well, bearing in mind that you are considering that independents have to get 80,000 votes to secure one seat, whereas a political party can contest for at least 200 seats by only getting, say, 40 or 42,000 votes. As against that, is this risk to one of 2% or less of a one-seat overhang, is that a risk that would cause your electoral system not to achieve proportional representation in general? That is one proposition. And I'd be interested to hear your argument then on what is proportional representation in general, because in general appears to indicate that it doesn't require the system to have perfect proportionality, but it requires it in general to achieve that. And one might say, well, if it achieves it for all parties other than one in 98% out of 100 elections, well, then in general it is achieving that. But then if we go to the Ling-Rosen report at page 178, their conclusion on the scenarios that they ran at the top of that page is, if I have it right, is that the last page of the report?
Yes.
They say, first, the deviation from perfect proportionality is the same for both electoral formulae. The distributions are almost identical. Second, the deviation never exceeds one seat, meaning that no party ever loses or gains more than one seat. As I understand that, they are saying that at a 200-200 split, there is also a risk of an overhang of one seat.
Yes. Because of the fractions and the Droop formula, there's always that risk, yes.
So on both systems, we have a risk of an overhang of one seat, but on your proposal, at least independent candidates contest for their 200 seats, requiring the same level of voter support as the political parties require across the board for the 400 seats.
Yes, not quite the same, Justice Rogers. If you go to page 67, we're still disadvantaged, but only by 10% as opposed to 91% and so on. So
the quotas then, the quota of voter support then more or less approximates it,
yes,
although it still favours the political party slightly. Is there any spreadsheet or data in our papers which shows us what the relative risks are of the 1% overhang on your formula and on Parliament's formula? Would you accept that although in both of scenarios there's a small risk of a one-seat overhang, the risk on the Parliament's 200-200 split is slightly smaller than the risk on your approach?
I don't think that they have quantified. I don't think they've quantified their risk in terms of how many percent chance there is of that particular risk eventuating. But one can accept there's a small risk and another small risk on our version.
I think you are right that they don't quantify it, but I suppose we could infer something from the fact that your own expert on the 200-200 split has the risk at 0%.
Yes, there's a small risk on one permutation of 0.03, but yeah, effectively, yeah.
Yes, that's right. On the
It is on page 75 at the 6% for minor parties on the 2014 election data, but that's negligible. We accept that.
So we're talking about a risk of 1%, of a one-seat overhang on your scenario of 2% or less, and on Parliament's scenario, a risk of a one-seat overhang on something less than 2%.
Yes.
Yes. So the question may be, does a risk of a 2% overhang cause an electoral system not to provide for proportional representation in general, whereas Parliament's version, let us say the risk is 0.05%, that suddenly does become achieving proportional representation in general? Because on the face of it, if one just looks at the numbers that are available to us, the risk on both versions seems to be so modest that one could say both systems achieve proportional representation in general, and then one goes back to the question, well, that being so, why is this disproportionate value of a vote in favour of the political parties to be tolerated?
Quite, Justice Rogers, and it's a massive difference. And going the 350-50 route, one reduces that unequal vote drastically. And I'm afraid that I didn't get there in the 15 minutes. But if you look at the page 67, 68, and so on, it is really a drastic difference. It is 91% excess on that particular scenario at page 67 on 2% support for the independents, and it's reduced to 10%. Now, on 25 compensatory seats, we can reduce it to 3%, but now the overhang risk becomes too much.
Yes,
you can't go below 50, and that's... Yes. The argument is essentially this.
So if I could go back with reference to the data that we've got from your expert and the Ling-Rosen report, how do those two sets of data and the risks they posit for an overhang? Because overhang is just another word for not achieving perfect proportional representation. How does the data available to us, where does it lead to in regard to the attainment or non-attainment of proportional representation in general, assuming for the moment that proportional representation must be understood as only proportional amongst political parties?
Both achieve it. 350-50 achieve overall, in general, proportional representation, and so does the 200-200. So Justice Skip has raised this issue, but we don't have to show that the 200-200 will result in disproportionality or not in general. We just say the two achieve both, but the one has got a major and massive advantage by restoring equality of the vote.
So the 200-200 split might attain an improvement of a fraction of a percent, closer to perfect proportionality, but at the risk of debasing the value of a vote for that an independent candidate needs to secure a seat.
And this is where Mr. Manoncela, when asked, well, why when Parliament was confronted with this obvious solution, let's go 350-50, because that maintains overall proportionality but restore equality of the vote, they then said, well, it's a policy question. We can essentially do, and what is the policy that sought to be advanced by that? Proportional representation, but it's not necessary because you achieve that on the 350-50 as well, and that is essentially our argument.
And it appears to me on this data we don't need, it might be said, well, you can't have a legislative electoral scheme which is dependent on certain percentages of support for independent candidates. But it appears to me that the effect of the data, as per the Atkins report, is that it doesn't matter if the level of independent candidate support sometime in the future goes above 10%, because the trend is always to get closer and closer to perfect proportionality, the higher the support for independent candidates.
That is so, Justice Rogers. Yeah. So, in a nutshell, from a justification point of view, It is, of course, arbitrary because they have no reason for violating equality of the vote, because the purported reason, the advanced reason, is overhang, and that isn't a concern on the 350-50. And it's, with respect, not disputed what Atkins did. And that's why that overhang part, table B, is of fundamental importance to us.
Thank you. I don't see any hands, Mr. Duval. Thank you very much.
Thank you.
Thank you. We are at 13 minutes to 12. We are going to take the short adjournment, and we are going to return at 12:05. The court adjourns.
It's not, yeah. Then, I can see this one is full. This one is. No, this one is not plugged in. No, it's not plugged in. We can't plug it in. No, you'll have to spend. But if you go. We can't plug in another one. But we shouldn't, because this one in Alamatata, we shouldn't fiddle with. Okay, no, it's fine. Because if we fiddle with it, because of your phone, not like this, I give you record. What I do is I just leave the charger there, and then all I do is just do this. Like the charger stays in the entire day. I'll take my mobile. Did you have his number? I got both numbers. So you told him to send him. No, don't speak to Sakani specifically. But I had to charge it. I told them what I'm taking out the battery. Why tell me so that man even you see? Yes, that's what I'm gonna say. I work at OB's. So
you know, into zakhona ukulalela khamba kanje.
for ziyakhala, zinokukhala.
Kade uyiphathanga i-breakfast.
Yeah?
Usually we bought breakfast at 7.
No, we have to buy for ourselves.
Mabata ka mo manu shetse batho ba bakae ukuthi sikone ke kuba tsase matse ngata ba ho ya banda ngapha inside yes mina ngizwa kushiza ya
Hayi.
into jwa oh plaza ugqoka mina ngiwom ngiyabanda
We didn't make sure. That's all. I have fair.
I get fired.
We got to worry. I never.
I right.
Marita, kota kana. Yeah,
independent. Bafuna ngitho ufuna ukuthi ama independent candidate. Actually, equal rights. Yesithe. Bana mo sitha kwenye 200. Ufuna half. No, 20. The number of voters.
Thank you everybody. Thank you everybody. May I have your attention please? Thank you. Let us take our seat please. Let us be ready please. Let us take our seat, let us start please. Thank you.
But now when they do crossings as well, they go like, it's nice to get someone who's going to explain.
So that's Baba Idur, Baba Level.
Yeah, when you ask them.
Thank you, Mr. Patlander. Your 30 minutes starts now.
Thank you, Chief Justice. Chief Justice, I appear today on behalf of the President and the Minister, but as you know, the President abides and the submissions I make today are on behalf of the Minister. Chief Justice, this court has, and I put this politely, a checkered relationship with the Minister of Home Affairs. The Minister of Home Affairs comes to this court, often I'm on the other side, and the Minister gets castigated for doing things wrong. Today I stand before you for the Minister of Home Affairs, and the Minister is here, and I need to say to you that whatever the Minister may have done or not done in other cases, this is a case, in my respectful submission, where government has done what they are meant to do. This is a case where this court gave a judgment I lost, but we'll try not to mention that. And the Minister followed the judgment by appointing a panel of independent experts. No one suggests there was anything wrong with them. No one suggests that they weren't qualified. The experts produce a report. 4 of them go one way, a more radical overhaul. 3 of them go another way, the minimalist option. The minister and government decide to follow the minimalist option. People, some of the applicants are unhappy about that, but nobody says that that choice was unconstitutional. Nobody says it was irrational. Nobody says it was impermissible. So we must accept that the law is rational, permissible, constitutional in following a minimalist option, because that is the case before you. No one takes issue with that. And so the only debate before you is around the fringes. It's around the mechanics. And I do want to use the words nuts and bolts, because it is nuts and bolts, and I'll come back to that. But be that as it may, the minister goes the minimalist route. He directs that a bill be prepared by outside counsel. The bill is prepared. It goes to Parliament. There is, as Justice Matopo says, an extensive public consultation process. Parliament, if anything, and I can say this, drove the minister mad by how much public consultation had to be held the first time in the NA, the first time at the NCOP, the second time at the NA, because Parliament did not want to make a mistake here. This was too important. During that public consultation process, everyone voices their views. Every time there's a technical concern, it gets referred to the IEC for advice. Every time there's a legal concern, it gets referred to the independent counsel for advice. The opinions are produced. The opinions are made public. They're all in the papers. Privilege is not claimed. They're put up in front of Parliament. And I might be wrong, but I don't think in any instance was the advice of independent counsel not followed. And every time a concern arises about unconstitutionality, the question is asked, the advice is given, and it's followed. The Act is passed with extensive changes having been made by the NCOP. Extensive changes. This is Parliament in action, doing what it's meant to do. Not just a rubber stamp. There's an NA bill, there's a major series of changes by the NCOP, including making this Act just a stopgap measure, because there's going to be a ministerial advisory panel which is going to be independent and is going to have to report on how this thing works in practice next year and what happens next. The bill gets passed, it goes to the President. The President is under huge pressure to sign it. You see that from the papers. He refuses. He says, I'm not going to be rushed. The President says, I want to consider it properly. I want my own independent counsel. He calls for that. He satisfies himself and he signs. Chief Justice, in this country, we sometimes are fond of saying government doesn't work. This is a case of government working. This is a case of Parliament doing what it's meant to do and the President doing what he was meant to do. And trying to fix, and I say this with all due respect to the members of the New Nation Court, trying to fix what is a very knotty problem. Because we accept, of course, New Nation, but one has to say that the New Nation judgment created a very knotty problem to solve, which is how do you introduce independent candidates into a system designed mainly around PR. Government's done its job. So when we hear in the question that Justice Theron put, well, isn't this just an attempt to make sure independents can't run, and it's sort of a Machiavellian attempt by political parties to safeguard themselves? And the question she rightly put, where is the evidence for that? And we are told, no, we persist in that submission. That is quite remarkable and it's disappointing. Because there is no basis at all for saying that this was some Machiavellian approach to prevent independents running. And in fact, as I will show you, even the 200-200 split, which is what's at issue in this case, is not something that was dreamt up by this Parliament to try and destroy independence. That 50-50 split is exactly the same under the Local Government Structures Act. And I'll take you to that. But it's exactly the same, and it's been in place for years. And we haven't had independent candidates complaining there. So it's just no basis for that. Now, of course I accept, and no doubt someone will put it to me when my protected time expires, of course I accept that motives don't cure unconstitutionality. Of course I accept that if this is unconstitutional, then the best motives don't fix that. I get that. But with respect, you cannot approach this Act with the jaundiced eye that the applicants and their expert do, which is to say this is all an attempt to unfairly treat independents. That is not a fair reading of the Act, it is not a fair reading of the parliamentary processes, and it is not the correct starting point. Now, against that backdrop, I propose to address 5 issues. The first is the principles, the second is the real dispute between the parties, the third is the flaw in the case, that's the regional seats, the way they work. The fourth is the reasons for the compensatory seats and the 200-200 split. And the final is the question of remedy. And how my learned friend, Mr. de Waal, with great respect, can say remedy doesn't seem to be an issue is beyond me, because we would submit that remedy looms large and demonstrates the problem with the applicant's case. But we'll get there. Now, with regard to the principles, we have set them out in our heads of argument at pages 14 to 22. The court will have read them. I do not repeat them. I will say only this. It would help if I had the file that has the heads of argument in it. Now I do. The principles we've gleaned from NNP, the principles we've gleaned from UDM, the principles go like this. Parliament is fundamentally given a wide latitude to set the way the election operates. In some countries, and in the interim constitution, the constitution says this is how many seats, this is how the ballots, that's not our country. It was the 93 constitution, it's not this. Parliament gets a wide latitude. Is that wide latitude a blank check? Of course not, because this court said so in New Nation. So Parliament must do what? It must act rationally, according to New National Party, and it must not breach any fundamental rights. But it is not a suggestion that every time Parliament passes a piece of electoral legislation, you apply freewheeling proportionality or reasonableness to it. And it is certainly not a suggestion that every time an electoral system produces a disadvantage for one player, that renders it unconstitutional. That is made clear by this court's UDM 2002 judgment at paragraph 47. But enough about the principles, they are there, the court knows them. So the second question is, what is really at issue between the parties? And we set that out in our heads expressly because it seemed to us with respect that sometimes the applicant's case missed that. We deal with it at pages 12 to 13, and no one has really taken issue with it, so it's important to say it again. The ICA does not object to three things. First, it doesn't object to the principle of there being two seats, regional and compensatory. Second, it doesn't object to the principle that independents can only compete for regional seats, whereas political parties can compete for both. I mean, when I say it doesn't object, it's very unhappy, but it doesn't suggest that there is anything unconstitutional about that. And thirdly, the ICA does not object to the fact that there are two ballots used and that both ballots count towards the second set of seats, which is what produces the unequal vote, if I can use it in inverted commas, or the unequal quota. So none of that is objected to. The only debate between the parties, and our learned friend Mr. Madonsela said so, he said the only debate between the parties is, did Parliament act unconstitutionally by reserving only 200 seats for which independents could contest? I thought he was suggesting it had to be all 400, but in answer to the question from the Chief Justice, it is clear. He says Parliament was constitutionally obliged to set aside 350, not 200. And that is the only debate between the parties. Did Parliament act unconstitutionally by adopting a ratio of 200 to 200, as opposed to adopting a ratio of 350 to 50? That is the only debate between the parties. Now, one would have thought, on the face of it, that that is preeminently a matter for Parliament. We're not talking about Parliament reserving 5 seats or 2 seats or something nonsensical. We're talking about 200 seats, half of the seats. But let me go further and deal with the third point. What is the core flaw in the case? And the core flaw in the case is this. If we just focus on regional seats for a moment, regional seats work that each political party and each independent candidate competes on an utterly level playing field for those 200 seats. If the quota is 30,000 votes per seat in Gauteng, then in order to get a regional seat in Gauteng, the ANC needs 30,000 votes. Mr. Budlander, as an independent, needs 30,000 votes. Mr. Matopo, who's decided to go into politics, needs 30,000 votes. Everyone needs 30,000 votes. Everyone knows. It's the same ballot, it's the same voters, it's the same quota for the same 200 seats. So when we speak about the diminishing value of the vote, we mustn't get the starting premise wrong. The starting premise is that for the 200 regional seats, independent candidates and political parties are not treated similarly. They're not treated in a similar fashion. They are treated identically. So therefore, and so when our learned friend says that he quotes Mazibuko about constitutional entitlements being rendered worthless, he quotes NNP about constitutional entitlements being rendered empty and useless. Can you really say that a system which introduced independent candidates for the first time and which allows them to compete for 200 seats in Parliament on an identical playing field to the political parties for those seats, that renders the ability to run as an independent or vote for an independent constitutionally worthless, empty and useless. Well, of course you can't with respect. You can say you don't like it. You can say that it makes it more difficult, which is what the real beef is. You can say you don't prefer it, but to say that it renders it constitutionally worthless, empty and useless is with respect without any merit whatsoever. So let's move past the regional seats, because in fairness to the applicants, their case is not about the regional seats. Their case is about the compensatory seats. And their case is, well, when you add them all together, when you throw in all the votes into the pot, then it's going to be easier for a political party to get a seat than it is for an independent candidate. Why? Because there are 200 seats reserved for them. That's the nub of it. 200 seats are reserved for them. That makes it easier for the political parties to do it, whereas if it was 350, it would be easier for independents. That's the crux of the case. But what we submit is that that decision to reserve 200 compensatory seats, that decision to make 200 seats compensatory rather than 50, because that's the only debate, that decision to make 200 seats compensatory rather than 50 was eminently rational, it was eminently reasonable, and it was plainly constitutional. Now, what was its purpose? And Justice Theron, with respect, put it perfectly. She said that she understood that there was a dual purpose. The first purpose was to achieve proportionality, and the second purpose was to prevent overhang. And those are two different purposes, and I'll come back to Justice Rogers' questions later on, but those are two different purposes. They might be related in some ways, but they are different. So why do we need to achieve proportionality via the compensatory seats? And the reason is given in all the papers. It's because independent candidates have the risk of distorting proportionality. Let's assume that I run for office, and for some reason, no one knows why, the public flocks to vote for me. And even though the quota is 80,000, I do fabulously, and I get 500,000 seats, 500,000 votes. I can only occupy one seat as an independent. They say that means there are 420,000 seats votes wasted. We say they're not votes wasted, but that's not the debate. The point is, there are 420,000 votes which are at odds with proportionality, because you've got 500,000 votes producing one seat, whereas if I was a political party, it would be 500,000 seats producing, now the maths is letting me down, 6 seats. So the problem is I got too many votes for my one seat, and that produces a distortion in proportionality. That risks undermining section 46(1)(d) of the Constitution. That was the very argument that we made last time in New Nation, to say, but then you're going to run into a proportional representation problem, and this court quite rightly said, not so fast. You can solve that problem. It's been solved at the local government level. It's been solved under the Structures Act, and it's been solved under 157 of the Constitution. And indeed it has. Because when you go and have a look at the Structures Act, and I will come back to it, but if I could just give the court a note, the Local Government Structures Act, section 22, sub 2, expressly says that you've got the same 50-50 split in every municipality. 50-50 split between a ward candidate and a ward seat and a PR seat. It's exactly the same 50-50 split, same ballots, etc. But so just to get back to my point, there is a problem with proportionality when you introduce independent candidates, and you have to introduce a law which fixes proportionality. Why? Because section 46 of the Constitution tells you so. 46(1)(d) tells you so. So Parliament designs a system which achieves proportionality. It restores the proportionality that the independent candidates have distorted. Now let me say, although there was some attempt to wriggle, as I understood it by the end, and that was in respect of Justice Skipper's question, as I understood it by the end, it is common cause that the 200-200 seat, the 200-200 result produces proportionality. That is exactly the point, that the 200-200 produces proportionality. Let me say the 350-50 does as well. So that's not the debate, but let me just focus on the 200-200. The 200-200 produces proportionality. So the first aim is ticked. Let me pause there. That alone means that the amendment can't be arbitrary. It can't be arbitrary because it is rationally connected to a legitimate governmental purpose. So there's no arbitrariness here. Now we go to the second aim. The second aim is to prevent overhang. Now, overhang is not some theoretical construct. It's not some theoretical concept. Overhang is a practical problem, and I'll come back to it if Justice Rogers has questions about it, because I suspect he will, because overhang is a practical problem where at the end of the day, the Electoral Commission has 401 people who are entitled to seats, and it only has 400 seats to give them. That's not a theoretical problem. That's not a fanciful theoretical delight. It is a practical problem, and it's a very serious one, because as the IEC tells you, it prevented certifying the results. And I'll come back to that. But that's then the second aim. The second aim is that it prevents overhang. Now, I will in a moment, perhaps in response to questions, take you to the Atkins report, because my submission is that the Atkins report makes absolutely clear that the prospects of overhang under 200-200 are not small, they are zero. I'm relying on the applicant's own expert, his table B at page 73. I'll take you there in a moment, but they are zero. So, there were two aims. Achieve proportionality. Does the 200-200 approach achieve proportionality? Absolutely. Prevent overhang. Does the 200-200 prevent the risk of overhang? Absolutely. So what's the problem? The problem is that the ICA and Mr. Atkins have come up with a different approach, and that's perfectly permissible. They come up with an approach of 350-350. Now let's assess the 350-350 against those two aims. Does the 350-50 achieve proportionality, the first aim? I accept it does. I have no difficulty with that proposition. I'm not going to try and squirm. I accept it does. But does it prevent overhang, the risk of overhang? The answer is it does not. And when you read the expert report of Mr. Atkins himself, based on the last two elections, it produces a risk of 6% overhang in the last election and 15% overhang in the previous election, applying those results. Now, of course, we don't know who's going to vote next year. We don't know whether it's going to be 6%, 15%, 18%, 3%. But over the last two elections, using Mr. Atkins' own report, the 350-50 approach proposed produces an overhang risk of up to 15%. Now, what does that mean? That means 1 in every 6 elections, statistically. Of course, we know they're statistically independent events, and I'm not going to talk about, it reminds me of my son coming home and asking me if I roll 3 6s, what is the odds of rolling a 4th 6? I'm not going there. But statistically, what it means is a 15% risk means that in 1 in every 6 elections, the IEC is going to be confronted with a crisis. A crisis which says we have 401 people entitled to seats and we only have 400 seats. Now, that is no fanciful proposition because it applies particularly in the context of regional parties. What is overhang? Overhang happens when you have a party that is particularly strong regionally. Let's say there's a party that's very strong in KZN, but very weak in the rest of the country. The party gets on the ballot, and it does so well in KZN that it's entitled to 13 seats in Parliament. But when it's mapped overall, at the second level, it's actually not entitled to 13. It's only entitled to 12. Now, with respect, would you like to be the member of the IEC that announces to the public that it's true that the XYZ party in KZN was entitled to 13 seats on the basis of the KZN vote, but unfortunately, due to the problem of overhang, they are now going to be reduced to 12. There's been a lot spoken about violence, disturbance, elections. That is a real crisis. That is a crisis where the IEC has to announce that a party that won votes, that won seats, is no longer entitled to it. Obviously, my 13-12 is just one example. But this notion that it's only 1 seat or it's not such a big deal, with respect, Parliament is eminently entitled, maybe even obliged, but eminently entitled to say, we see a risk there, and we want a system that avoids the risk completely, i.e. the 200-200, 0% chance of risk on Atkins' own report. And we don't want to adopt a system which is 350-50, which produces Atkins' own report a risk of up to 15%. Is Parliament entitled to do it? Of course it is. Of course it is. So, with respect, when we speak speak about this 200 compensatory seats, there are three things that I would emphasize. The first is that it's not dreamt up out of nowhere. And if I can just spend a moment on that, again, I've referred the court to section 22 of the Structures Act. It's 22.2, and what it says is the number of ward councillors in a metropolitan or local council must be equal to 50% of the number of councillors determined for the municipality in terms of section 20. If the number of councillors determined in terms of section 20 is an uneven number, the fraction must be rounded off upwards. So they are absolutely intent on 50-50. That has been the law for years. And of course we know independent candidates run there. And then in relation to how the ballots are counted, you can go and have a look at item 12 of Schedule 1 to the same Act. Item 12, Schedule 1, under Part 3 of that schedule, there's a heading saying PR elections, and there's a quota. And it says the quota shall be calculated as A over B minus C plus 1, where A represents the total number of valid votes cast for all parties, consisting of those cast on the party vote and those cast for ward candidates representing parties. So the municipal system is identical in the sense of its 50-50 split. Now, I don't suggest that means it's constitutionally immune, but it shows where it comes from. And we know that in our country's history, we've always had 200-200. Just a different way of thinking of the 200-200. A last point on the municipal point. Because the municipality, no municipality has 400 seats. So municipalities have often you have small municipalities of 10 seats or 15 seats. Because of that, there has historically developed an overhang risk even at municipal level. And that is why there is this amendment, which our learned friend referred to for the first time, and that is item 16 of the remedy. Now, our learned friends seem to say, well, that solves your problem. You can just have that remedy. I would ask the court to go and read item 16 of Schedule 1 to the Structures Act. It is 9 sections, and it includes a formula which says the new quota for seats shall be determined in accordance with the following formula: A minus B over C into D plus E, all plus 1. This court will know I'm somewhat adventurous when it comes to advancing reading in. I don't think this court is likely to be reading in A minus B over C into D plus E plus 1. With respect, the suggestion that that is a remedy and that that solves the problem, when that was never advanced as their solution during parliamentary hearings, it is not the relief sought in the notice of motion, and it demonstrates that overhang is a real problem. It's such a real problem that at the municipal level, and again I want to be clear, there's no overhang risk at 200-200, but at municipal level, because it's 15-15 or 10-10, there is an overhang risk. It's such a problem that Parliament has had to initiate this item 16 issue. So, Justices, if I could take a step back, where are we? We have a system which at regional seat level treats independent candidates and political parties identically. We have a system at compensatory level which treats them disparately. It says only political parties can run for those seats. Why does it say so? It says so because independent candidates produce a distortion of proportionality. And so it does two things. It aims to do two things. It aims to achieve proportionality, it aims to prevent overhang, and it does both. The common cause evidence, and I will go there if I need to, is that it does both. Contrast that with the system that is proposed by the ICA, 350-50. It does the first, but it doesn't do the second. But let me assume against myself for a moment. Let me assume against myself about that 350-50. And let's assume that even the 350-50 ticked both boxes. They ticked the proportionality box and it ticked the overhang box. On what principle of law is this court entitled to say there are two ways of achieving these aims, and we prefer the one that advantages independence? On what principle of law is this court entitled to say there are two legitimate ways of doing it? We prefer one that Parliament did not choose. Even if you go back to Grootboom, and we've quoted Grootboom for you, where really the court went as far as imagined is saying it was prepared to re-look at government policy and the choices that are made, then not in legislation. This court said what is reasonable is not about the most advantageous, the best, the rest. There is no basis So even if you assumed, and you can't, but even if you assumed that both systems simultaneously achieved both aims, that would not be a basis to invalidate the one Parliament has chosen. Why? Because it was Parliament's choice to make. Chief Justice, that leads me to the very last point. Oh, and sorry, let me say, and I can come back to it if needs be, and I will, but there is a risk with respect that what this court gets, the court gets sucked into the expert reports without regard to the affidavits. Because my learned friend, Mr. Duval, for example, analysed the Atkins report minutely, line by line, table by table, calculation. He made no reference at all to the answering papers. Now, I would ask the court to go to the answering papers dealing with the overhang problem. And I would ask the court particularly to go to the Electoral Commission's answering affidavit at 153 to 156, paragraphs 29 to 36. Because when you go there, you will see the overhang problem writ large. Now, if the case of the applicants was that is overstated and there's nothing in it, then with respect, we are in application proceedings here, and this might be direct access, but it's still Plascon-Evans. And if there was an attempt to show that the allegations made by the Electoral Commission, which is the constitutionally ordained expert on this, were wrong, there had to be leave sought to file a replying affidavit, and it had to say what appears in paragraphs 29 to 36 is wrong and can be rejected on the papers for the following reason. Or there needed to be a request for oral argument. But with respect, we're all on board that this has to be determined quickly. We're all on board that direct access has to be granted, but we're still in Plascon-Evans. And the Electoral Commission is an opposing respondent making allegations about matters squarely within its expertise, and with respect, that should be the end of the debate about the overhang problem. And the same, by the way, if it was contended that the Electoral Commission's affidavit is contradicted by the Ling expert report, which I'm going to demonstrate if I need to is not, if that was the case, that needed to be pleaded, needed to be dealt with. It couldn't just be raised in written submissions. And there had to be, if leave had to be sought to file a replying affidavit, then that was the position. So just to finish off the references, I'll just give the court the references. If the court would have a look at the minister's affidavit, I'll just give the paragraph references if you wouldn't mind. It's 30.4, 160, 190.2, and 207. And in Parliament's answering affidavit, 17.3, 70.5, and 70.7. But in truth, all you need to do is read the Electoral Court's affidavit. But that brings me to the last question, and that is, what about the question of remedy? Because when our learned friend, Mr. Madonsela, was pressed on the point, he said, well, it's just a debate about remedy. You don't have to worry about it. But, Chief Justice, what is the remedy? Because when you go to the notice of motion, the notice of motion calls for the narrowest reading in. Strike out the words 200, 200 and read in 350, 50. There is no equivalent of item 16 read in. There is no explanation as to what the IEC will do if next year there is an overhang problem and they have an additional MP who cannot be sworn in. There is no answer at all. So if you are against us, and we submit you shouldn't be, but if you are against us, you certainly can't adopt the reading in. And we've made this point, which is why I found our learned friend's submission somewhat surprising. You can't just read in 350, 50. At worst, what you would have to do is declare it invalid and suspend. But there would be really little point, because Parliament is going to be confronted with this difficulty. But if you are against us, and let me be unequivocal, the only remedy you could grant would be a declaration of invalidity, suspended for a period of 2 years, and allow Parliament to fix, and the existing elections would have to go in accordance with this scheme. Chief Justice, those are our submissions. I've touched on other issues, and I'm happy to deal with them in answer to questions.
Thank you. The invocation of Plascon-Evans in this court can't be an easy issue. Cannot be an easy issue because, one, this court wouldn't listen to oral evidence, isn't it? Whereas normally Plascon-Evans is applied in a court where the court can hear oral evidence. That's one. maybe you achieve the same result by not invoking Plascon Evans, but by saying, although these are direct access proceedings, the respondents filed their answering affidavits. The applicant did not say that it will be prejudiced if it can't get a chance or leave to file, to reply. Yes. And where it didn't do that, the court must then decide the matter on the basis of the respondent's papers if there is a dispute.
Chief Justice, you're quite right with respect. You don't need to go Plascon Evans because normally Plascon Evans emerges only where there's a dispute of fact over 3 sets of papers. Here there is no replying affidavit filed in answer to the respondent's answer, and that is the end of the matter, where there is, with respect, it's a much easier route through, and I endorse the proposition, if I may.
I'm looking at Justice Rogers.
Yes, I'm not going to take you through the mathematics, but since the beeper cut you short of telling us why Ling Rosen doesn't mean what it says,
yes.
Perhaps you can just explain what it means.
Yes, if I could, Justice Rogers, and that is this. There are 2 different concepts, if I might. The first is a mathematical concept, which is when one applies a set of electoral rules and applies them to a set of votes, how much deviation from perfect proportionality is there? In other words, it's not a debate about you've got too many people for too little seats. It's a question of a deviation from perfect proportionality. And that is what Ling Rosen deals with, and I'll give you a reference in the papers. It's in the IEC's affidavit, and it says, it's page 154, paragraph 33. Mr. Atkins describes this as a small caveat. It will not result in a significant risk. The Commission does not agree. The risk of overhang is by no means a small or insignificant matter. Deviation from perfect proportionality is unavoidable. Footnote 34. For instance, the deviation in the allocation of seats that might result from the unavoidable use of whole numbers in the allocation of seats, as described in the Ling and Rosen report. So that is a principled question about statistically, is there a deviation? In other words, it's about when you look at the 400 people, is there a deviation from the principle? The overhang problem is different. The overhang problem is about where you have more people than seats. And Justice Rogers, could I take you to Atkins on that, please? Because you took my learned friend there, and it's important because with respect, we have a different read of what Mr. Atkins says. It's at page 73 of the papers. Sorry, let me just say. So we say Ling Rosen is answering a different question from Atkins. Ling Rosen is answering, does this system produce a more than statistically acceptable, this 200-200, does it produce a more than statistically acceptable deviation from proportionality? And the answer they give is no, it might be 1 seat, but that's statistically acceptable. But that's a principled question. But then if you go to Atkins...
Sorry, but just explain that.
Yes.
When they say the deviation never exceeds 1 seat.
Yes.
What does that mean? That out of, say, the 200 compensatory seats, or all the proportional representation seats that go to parties,
yes,
there will still always be enough seat, but one party, because of the way the seats are allocated, I still don't understand, the deviation never exceeds 1 seat.
Yes.
I'd understood that to mean that there could, under certain circumstances, be an overhang of 1 seat.
No, with respect. My understanding in the Electoral Commission affidavit, it doesn't explain it. And of course, if this challenge had been mounted, it could have been explained. But it makes the point between avoidable and unavoidable risk. Just find me that reference in the head. Unavoidable and avoidable risk. There is an unavoidable risk of deviation from proportionality whenever you have, in any election, because of the whole numbers fractions problem. And what they are explaining is what is the extent of the unavoidable deviation from proportionality. And the answer they give is, don't worry, it's never more than one seat. In other words, it's not statistically relevant. And they are doing that by looking at the 400 seats allocated. The overhang problem is not a principled issue. It's a practical problem, which is that for practical reasons, and I'll take you to Atkins, for practical reasons, you end up with an extra person entitled to a seat, and you can't allocate it. And that's the question Atkins answers. And those two are not the same. The Electoral Commission makes the point in its heads, because of course it's the first time it was raised by the ICA, but if I could point you to the Electoral Commission's heads at paragraph 21. What they say is, where Ling and Rosen expressed, well, let me read it properly. ICA submits that there's an acceptable risk given the benefit it produces of equalising the vote. To support this conclusion, the ICA points to the Ling and Rosen report that the Commission produced. However, the report does not address the problem of overhang. Where Ling and Rosen explain the view that a deviation of 1 seat is within the bounds of, quote, in general proportional representation, they do so in assessing the unavoidable impact of applying the droop method to whole numbers of votes cast and seats, and in discounting fractions in the allocation of seats. In this context, there can be no dispute with Ling and Rosen's conclusion. What the ICA proposes is quite different, the adoption of a seat allocation model that creates an avoidable risk of a disproportionate outcome. Now, the droop method, as this court will know from the papers, is a method by which elections take place and quotas are calculated. And there are two broad methods in the world. There's the droop method and there's the hare method. Our country has adopted the droop method since the inception of democracy. The problem with the droop method is that sometimes it gives rise to some degree of disproportionality. And the question that is asked is, does that degree of disproportionality undermine the requirement of in general proportional representation? And the answer given by Ling and Rosen is, no, it doesn't, because it's only 1 seat within the 400. It's an unavoidable, at worst, it's an unavoidable deviation of 1 seat, but there are no practical problems because it's done within the 400. The Atkins report deals with overhang, and Atkins says, on my 350 versus 50 problem, there is a risk of between 6 and 15% of an overhang.
For the small party at a level of 1% for the independent candidates on the 2014 results. I accept that that is what it says.
Absolutely.
Yes.
But Justice Rogers, could I take you there? Because it's the contrast between the first column and the fourth column which matters. If you go to page 73, now, of course, what Mr. Atkins is doing is he's applying these principles to the 2019 election data, and of course he is guessing, and that's not a criticism at all, he's guessing what the proportion of votes independents will get. We have no idea whether it's going to be 0.5%, 1% or 10%. But what he says, if you look at that first table, he says, if for the main parties, there is a probability of overhang of 2.03%. You see that from the fourth column, the second line. That's 50 seats, there's a risk of 2%. Now, if you go back to the left-hand side...
That's if independents get
1%.
Only 1%.
Oh, absolutely, absolutely. And we don't know, of course, Mr. Atkins doesn't tell us what the risk would be if independents only got 0.5%. Of course, one would think, given the trajectory, the risk would be higher than 2 on the basis of the proposition. So I'm trying to read it fairly. I'm not saying it's definitely 2%. It could be that it's actually as high as 3 or 4 as it goes up, but it could be lower. I mean, that's not the debate. But he raises a 2% risk in that scenario. If you go back to the left, what is the risk on the 200-200 split? 0. Then if you go over the page, so that's just the prospect of a major party getting an overhang. But then, Justice Rogers, you have to add to that the risk of a minor party giving an overhang. That's over the page, and you see that in the first line, 1%, 6.88%. So the risk of a minor party getting an overhang is 6.88%, and if you go back to the left, the risk that's under 350-50, and under 200-200, the risk is 0. So on just the 2019 election results, it's clear. Under all scenarios, the risk of overhang for 200-200 is 0. You can look at that left-hand column, 0, 0, 0, 0, 0, 0, 0, 0, all the way down. For 350-50, the risk of overhang is somewhere between 0 and 6.88%. I don't know whether you add the 6.88 to the 2, but it doesn't matter. The point is at least 6.88%. That's 2019. Now let's look at the next table, because he does the same thing again. The 2014 election data, and you will see in the first line, we're again dealing with main parties. He says the risk of overhang for the main parties, one seat, is 0.93%. So 350 gives a 0.93%. That's a pretty small percentage, I accept. But you look at the left again, what is it for 200? Zero. No chance. Then you go down again to the next table. You'll see for minor parties, the probability of overhang is 15.08% for 350, and for that's for minor parties, and for 200, zero. So if I can summarize it fairly.
Sorry, just before you
Yes.
summarize it fairly, as I'm sure you will do, for the minor parties, I think this is what Mr. de Waal referred to. At 6% level of support on the 2014 results, on the
Yes.
200 method, there is a marginal risk of
Yes.
an overhang.
Yes.
So, subject to what the Chief Justice says, and I think there was a direction that the expert should be here, I would like confirmation that when Ling Rosen talk about no deviation by more than 1 seat, they are talking only about 400 seats and
not
an
401. They're not my expert with respect. So could I perhaps leave that to Mr. Baum to deal with?
Yes.
Because it would be inappropriate for me to do so. But could I just answer the proposition that you've put to me? It is true that in one instance, so I count of the 1, 2, 3, 4, 5, 6, 12, 18, 24, 30, of the 36 instances that Mr. Atkins has tabulated, there is 1 out of 36 instances where there will be a 0.03% of overhang in 200. 0.03%, if my maths is right, is 3 in 1,000? 3 in 10,000?
Every 3,000th election.
Every 3,000. So yes, Justice Rogers, if the proposition is that there is a risk of overhang in every 3,000th election, then I accept the proposition. But contrast that with the 350-50, where the risk can be as high as 15%. And that, as I say, and as we know, that's a risk of every 6th election. Now, it is not for me to persuade you whether 15% is important or not important, but what it is for me to persuade you is Parliament is perfectly entitled to say, we know there's this risk in one scenario, and it is a risk which is only 15%, but it will be catastrophic if it occurs, and there is a risk in the other scenario only every 3,000th election, and none of us will be here for those, thankfully. Parliament is perfectly entitled to say we prefer that solution because we're trying to avoid the risk. And again, it's all very well for our learned friend Mr. Madonsela to say, well, they could have put in place a mechanism like item 21 of new item 21 of the Structures Act. That's the one which is A plus B plus C over, no, A plus B over C into D plus E plus 1. Sure. But with respect, that is a classic example of Parliament doesn't have to do it. So with respect, if we go back to the 2 questions, Justice Rogers, does 200 achieve proportionality? Yes. Does 350 achieve proportionality? Yes. Overhang, one produces the risk and one doesn't, in broad terms. So our submission is in that regard, there can be no debate that Parliament has acted unconstitutionally.
Did you get that right?
Well, what I mean is there can be no serious contention that Parliament has acted unconstitutionally when it's aimed to achieve 2 plainly legitimate aims, and where its method is not only rationally but reasonably capable of achieving those aims.
Of course, going back to the issue that caused you to refer to pluscon events.
Yes.
In some of in their affidavits, the respondents have places where they have given explanations for certain decisions or for certain things that form the basis of their contentions.
Yes.
Now, we have a situation where the applicants have not filed any affidavits to challenge those explanations.
Yes.
is the effect thereof that those explanations therefore stand, or is it not that simple?
Yeah, we have two submissions, Chief Justice. The first, there are two ways of dealing with such an explanation as an applicant. The first is to say that that explanation is not true. And then you have to file a replying affidavit and explain why it's not true, and then there's a dispute of fact and we can have those debates. That hasn't happened. The second is to say that explanation doesn't justify the approach. So it's true but not good enough. But even in those circumstances, one normally has to file a replying affidavit because you have to plead your case. You can't just do an oral argument. There is a case, I think it may be called BHP Billiton versus Finishing Touch. It's a decision of the SCA, and it says where new matter, you can sometimes file a replying affidavit putting up new matter where you wish to make a point that emerges from the answering affidavit. So if they had sought to file replying affidavits to make out a different case or a new case or to say your own reasoning doesn't support that, they could have sought leave to do that, but they didn't. And what they can't do is just arrive in their heads or an oral argument and say it. In circumstances we really know, because of course what Finishing Touch says is, if that's the case, then normally you must give an opportunity to the other party to file yet another set of affidavits because they have to respond to the new case. And with respect, that simply, it hasn't happened here. There's been no attempt. So the short answer to your question is that is the end of the matter. The explanations have to be accepted as true, and the explanations have to be accepted as rationally and reasonably connected, because there's no factual or legal allegation made that why that's not the case.
Of course, it should be open to them to say, we don't have to file any affidavit. We are simply saying that explanation coming from the respondents, you don't need to file an affidavit. If you just look at it, it doesn't make sense.
Yes,
something
of course.
like that.
Of course.
It's open to them to say something like that.
I mean, it's not Black on Evans, but it's the equivalent, which says sometimes you can look at it and it's so palpably ridiculous that you can say, just ignore. Oh, this is not this case with respect.
Yeah, or it's contradicted by something else in the affidavits of the respondents.
Exactly.
Yeah. Okay, all right. Thank you. Justice Colopin.
Thank you, Mr. Butler. Just two questions. In your assessment or weighing up of the models, and I'm not suggesting you accept that this court has the right to weigh up these models, because you suggest it may not, unless there's a basis for it to do so. Is it your conclusion that where a risk of overhang exists, notwithstanding at what level, as opposed to zero risk overhang, that question will always be dispositive of dealing with the issue?
No, that's not my submission. And let me, thank you, it's a very helpful question, Justice Colopin. Can I use an extreme example to prove the point? Let's say that the risk of overhang was only 1%, at worst. And let's say that the only way of remedying that risk was that you could only allow independents to run for 10 seats. You would say that independents have not been given a proper opportunity to run at all, because they've been confined to this tiny little pen of 10 seats, and that no risk of overhang could ever justify it. So I absolutely do not say that overhang is a silver bullet, but what I do say is that when you consider the proper opportunity given by the 200-200, and you weigh that the risk of overhang is certainly a legitimate basis to prefer, as Parliament, 200-200 versus 350-50.
Which actually leads me to my second question, when you refer to a proper opportunity.
Yes.
I mean, this case is about how we select people who represent us.
Certainly.
And the idea that independent candidates can stand is not an accommodation to them, but a right
Certainly.
that they're able to assert arising out of Section 19.3. Now, when you argued that even if one assumed that proportionality existed equally on the two models, which it doesn't, and even if the risk of overhang was minimal, you posed the question, what principle of law would entitle this court to interrogate that?
Yes.
If one said that the one model effectively excludes both voters from making a choice, in a sense that on the second ballot, if a voter says, for example, I don't wish to exercise either of my votes in favor of a political party, but only in respect of an independent candidate, that choice will be respected 50% only. That choice will not be able to be exercised in respect of the second ballot. And similarly with independent candidates, their right to stand for election, which Section 19.3 guarantees, would be limited. How does one factor that into the bigger question with regard to the impact of that model on, in a sense, the democratic space that's created?
So could I begin with the independent candidates and then move to the voters? On the independent candidates, they could never in that situation construct a plausible argument which says my right to run has been undermined, because they are given a right to run for 200 seats. All that's happened is that they are not given a right to run for a separate 200 seats. Now, I accept if the first set of seats, the regional seats, were winnowed down to 10 or 15, which made their task really impossible, or which meant they could never achieve anything in Parliament, then maybe there'd be an argument. But in this case, if the country feels that there needs to be a shift towards independence, then notionally there could be 200 independents in Parliament because there are 200 seats available. So I can't see on this scenario how it can be argued that they don't have a real opportunity to run. But I accept that if it was winnowed down to 10, that would be different.
Yeah. Except, Mr. Butland, all those independent candidates, notionally who wish to run, are confined to running on one ballot.
Yes. But
that's a limitation.
Well, I suspect we may, with respect, part ways on whether it's a limitation or whether it is, just as NNP said, it is one of the pieces put in place for the election. But if it is a limitation, in my submission, it's plainly justifiable and reasonable because it achieves proportionality. But let me deal with the first question. And the first question is, well, what about voter X who says, I don't want to vote for any political party. I only like independence. I hate party politics. I don't want to vote. Well, that voter has the same right as any voter in any election, which is to spoil his ballot or not cast it. And so he can say, I vote for De Beer in the first ballot, and on the second ballot, I write across my ballot, as some people used to under apartheid in a feeble protest, unban the ANC. It's part of the political rights under Section 19 are to exercise a right not to vote. And you would be entitled to say, I do not like political parties and I refuse to vote for them. And that would be a perfectly legitimate choice.
Okay, except that's a wasted vote which could have counted had the proportion been fixed differently.
And that is the question that voter has to weigh up. Would I like to vote for no political party, meaning that everyone else's votes count more, just by that little bit, or would I like to vote for the least bad political party? And that is what a lot of us have to do in a lot of elections. Is seldom do we find a political party that perfectly fits our aims, and we have to make a choice that least badly skews away from our aims.
Justice Skippers.
Mr. Budlander, I don't know if you touched on the so-called equality of the vote argument, because if we are with you in relation to the rationality of the act that is impugned here, then it leaves the next question as to whether the system that Parliament has designed infringes any fundamental rights. Now, I must say, when I looked at paragraph 38 of the applicant's heads.
I'm sorry, which paragraph?
Paragraph 38.
38.
Of the applicant's heads.
Yes.
There is no direct challenge, it seems to me, but rather a set of hypothetical questions as to whether conceivably this could have been intended or whether this could constitute an infringement. There's no direct frontal assault that this is an infringement. Am I misunderstanding it? And then how do we deal with that?
So we would submit that this notion of equality of votes needs to be treated with considerable caution, because it derives, the notion that we're all equal and that we all have the same right to vote, of course, no one's going to cavil with. But the foreign jurisprudence which is relied on is foreign jurisprudence primarily from the US in the context of gerrymandering. And in the context of gerrymandering, what that means is that some partisan commission sets it up so that when you vote for the Republicans are much more likely to get seats elected than the Democrats because of the way you construct the areas. Now, and that's what happened. That is the risk of a constituency system, and we know that that's what happened in 1948 in this country, and that's why we have Section 46(1)(d), which says we have a proportional representation system. So, if you're asking me, is Parliament entitled to treat voters differently and say, for example, some voters can only vote once and some voters can only vote twice? Or, no, of course not. But in this case, all voters are treated equally. all voters have the right to vote for the 200 regional seats, and all of their votes count the same for those 200 seats, whether they vote for an independent or a political party. When it comes to the second set of seats, it is true that if you want to vote for an independent again, you can't, but that is a consequence of the need to achieve proportionality. And let me say, Justice Skippers, it's why I go back to my first proposition. The applicants don't bring a challenge which says you could never have had this list system and you should have had pure constituency systems and etc. They don't bring that challenge. Their challenge itself accepts an inequality of votes. It's just that it's an inequality because it only relates to 50 seats and not 200. So it's a matter of degree. And so therefore, you ask me, is there a frontal challenge in paragraph 38? I don't know. I had the same difficulty in the heads. But my submission is, if there is a frontal challenge on that basis, there is none made out. And certainly the US case law on gerrymandering is just decidedly unhelpful on that proposition.
Yes, thank you.
Thank you. I don't see any other hands. Thank you, Mr.
Thank you, Chief
President.
Justice, members of the court.
We are at 4 minutes past 1. Maybe, if everybody agrees, we could take Council for Parliament, at least cover the 30 minutes, and then take from there. I think my colleagues are fine with that. Is that fine with Council? Yeah, thank you. All right.
Thank you.
Your 30 minutes starts now.
Thank you. Chief Justice, members of the court, there are 5 issues that I intend covering in my oral submissions today. The first is to provide some context to this challenge in relation to the process that was followed in Parliament. I'll be brief on that, and I accept at the outset that the reason for doing so is simply to alert this court to the very detailed, careful and cautious process that Parliament followed. The second is to briefly deal with the applicable legal principles on this, which we've dealt with in some detail in our heads of argument. The third is to deal with the underlying purpose for the 200-200 split. The fourth is to explain why in our submission there's no constitutional infringement, whether at the level of rationality or at the level of a rights infringement. And the fifth is to make some brief submissions in relation to the question of remedy. So, Justices, members of the court, in terms of the first of those topics, if I could start by saying this, Advocate Madansela said, Parliament took a shortcut approach in effecting these amendments. The submission is that Parliament's affidavit demonstrates nothing further than that. And if I could perhaps just highlight these points. The New Nation Movement judgment was handed down in June 2020. The Minister established the Ministerial Advisory Committee. A group of highly esteemed counsel, 4 in total, were briefed to prepare an initial draft of the bill and to provide advice on an ongoing and regular basis in relation to the amendments. The court will see from Parliament's affidavit, each one of those memoranda sought are attached to that affidavit. And in relation to those memoranda, they totaled 7 in total. Specific questions in respect of constitutionality were asked, and specific answers were given. The various amendments that the bill went through demonstrates that those answers were seriously taken on board. The court will also see from Parliament's affidavit that there were a total of 20 meetings of the Portfolio Committee, 8 meetings of the NCOP at which this issue was discussed and debated. This court will note that even after the bill was passed by the NA, it went back to the NCOP. There were certain amendments that were effected, and it then went back to the NA with yet again more amendments that were effected. Members of the court, that's a summary of what's set out in some detail in our heads of argument. It's section C at page 6 and following. There is, however, one significant point in relation to the split that emerges from the record, and if I could give the court the reference, it's page 370 and page 434, 435. And what the court will see from those references is that a concern was raised about the 200-200 split. An alternative proposition was put forward as to adjusting that to reflect 300 versus 100, and that was specifically engaged with. So we submit that this challenge isn't anything novel. It featured in the process. It was rejected in the process. That notwithstanding, the import of some of the interim relief sought cuts across that very decision that Parliament made. If I could then move on to the next topic, and that's just the legal principles. We deal with that in our heads of argument at section section C, page 13 and following, and section E, page 27. Members of the court, for present purposes, I just want to perhaps summarize 6 key principles. As the court is aware, this challenge is founded on rationality in the first instance and a rights infringement in the second instance. It might be helpful to go to our learned friends' heads of argument on that point, and from where Justice Skippers took my learned friend Mr. Budlander to, if I could ask that we start at paragraph 36. And the submission, Justices, is that at paragraph 36, we have the applicants identifying what, in their view, are the actual constitutional challenges in this matter. And you would have noted from Parliament's heads of argument, our submission is that these 5 subsections really boil down to a rationality inquiry, which includes a section 9.1 inquiry, it's effectively rationality, and a section 19.2 and 19.3 inquiry. And so for that reason, Justices, in dealing with the submissions here, I limit myself to deal only with the legal principles in relation to rationality and in relation to rights infringement. So turning then to the principles in respect of rationality, we've set them out in detail, but in summary, point 1, it's a narrow and objective inquiry. Point 2, Parliament is given a wide discretion in selecting the means, particularly in relation to its electoral system, to achieve a constitutionally permissible objective. Point 3, the inquiry is not about whether the objective could have been achieved in a better way, or about the fairness or the appropriateness or the reasonableness of the measures that were taken. So too, this court has said on many occasions that it's the court's preference as to what's appropriate is immaterial, and that rationality isn't a master key that unlocks every door, anytime, anyhow. And lastly, that there's a distinct difference between rationality and reasonableness. They ought not to be conflated. Justices, you will note from our heads of argument, we rely very heavily on this court's judgment in New National Party for the purposes of the analysis that this court must undertake. And we do so with particular reference to paragraphs 19 and 20 of that judgment, where this court said that when one deals with the rationality inquiry, the first question is there a legitimate government purpose to be served? And if that's met, that's the end of the inquiry. The second is there an absence of a rational relationship between the means and the purpose? And the third is, of course, whether or not any fundamental rights are infringed. Justices, you'd note from that judgment at paragraph 20 that this court said that an objector bears the onus of showing a denial of the right. And importantly, any scheme designed to facilitate the exercise of that right carries with it the possibility that some people will not comply with its provisions, but that does not make the scheme unconstitutional. As this court said, the decisive question is, when can it legitimately be said that a legislative provision designed to achieve a particular outcome, in this instance give independent candidates the opportunity to vote, results in a denial of that right? And the court went on at paragraphs 23, 37 and 39 to say that a provision would infringe the right if the probable consequence is that those who want to vote would not be able to do so even though they've acted in reasonable pursuit of the right. And the last point is at paragraph 24, the court highlighted the difference between rationality and reasonableness. Justices, if I could move to the third head, and that's the purpose of the 200-200 split. And I think that we deal with this in our heads of argument in section D, page 18 and following. We've provided a fairly detailed explanation as to where it comes from, but for present purposes, if I could perhaps just underscore the following. The first is that the compensatory seats and the regional seats serve entirely different purposes. And the compensatory seats, its common cause in this matter, and Mr. Atkins accepts, serve to protect against a distortion of proportionality. The second point is that it is accepted that on the 200-200 split, there is no risk of overhang, other than for the small point that was raised earlier on. And the third is, if I'm going to ask the court to go to the Atkins report, and if I can ask the court to start by looking at page 54, paragraph 19. And the court will see there that it says that at 50 compensatory seats, there's a low to moderate risk of overhang of no more than one seat, whereas there's a zero or negligible risk of overhang amounting to more than one seat. And then if the court would go to page 70, and there the court Mr. Atkins says at paragraph 70 and following, he sets out the allocations, and then he says the seat allocations will ensure that the outcome is proportional and it meets the requirement of 46(1)(d) of the Constitution, with one small caveat. It's well known that compensatory seats ensure the outcomes in mixed-member proportional representations systems are proportional by protecting against substantial overhang, where parties may obtain more seats in constituency elections than their overall proportional share of seats. And then if the court would just bear with me, and if I could direct the court to page 72, where the risk of overhang is then dealt with in relation to the three separate categories. And I'm not going to go into those tables again, other than just to make the point that the highest point at page 75 is the 15.08. And the last, Justices, is at page 27, paragraph 87, where we're told in the 2014 election, the noticeable risk of single-seat overhang stems largely from the risk of the minority, case of the minority front, and it then goes on. At 89, it says, what emerges is that parties with strong regionally biased support may have the risk of overhang, but that the circumstances where this happens are limited, and overhang is limited to a single seat. Importantly, Justices, in our learned friends' heads of argument, at page 18, paragraph 34, They recognise that there is the risk of overhang on the 350 to 50, and they say it's a low to moderate risk, but they accept that the maximum is at 15.08%, and then they go on to say on the 200-200 split, there is no real risk of overhang. And then the court will also note in their heads of argument at page 33, paragraph 64 and following, they deal with the IEC's conclusions and justifications, and then they go on to say that at paragraph 66, according to Atkins, the risk is between 6.88% and 15.08%. And the high water mark of the argument, I think, culminates at paragraph 71, where they say, to the extent that this is an avoidable deviation from proportionality, it's fully justified in order to ameliorate the violation of the equality of the vote. So we submit that overhang is a serious risk. It's common cause that it doesn't present on the 200-200 split, and it does in fact present on the 350-50 split. And so for all of those reasons, we submit that there is in fact a rational, reasonable and legitimate purpose to be served. It's in terms of ensuring a system that ensures proportional representation in general, and it's one that avoids an overhang. If I could then go to the second last of my submissions, and that is the issue of the constitutional infringements. That, Justices, is dealt with in our Heads of Argument section E, page 26 and following. We submit that the claim of irrationality doesn't get off the starting blocks. And we say that it doesn't because, for reasons I've just addressed, there is a legitimate purpose to be served by the 200-200 split. It avoids any risk of overhang, and it does result in an electoral system that results in general in proportional representation. As regards the rights infringements, Justices, on the analysis, we submit that there is no rights infringement at all, because the rights that are invoked are sections 19.2, which deals with the rights of citizens to free, fair and regular elections, and the rights in section 19.3 to stand for public office and, if elected, to hold public office. For reasons that this court has already engaged in, we submit that the regional seats are eligible to are available to independent candidates and political parties alike on an identical quota, on the same criteria, and there's nothing that's objectionable about that. We submit that, properly construed, the real challenge is that the compensatory seats are in fact not available to the independent candidates. And that's why they're driven to raising a challenge that suggests let's alter the numbers in relation to the compensatory seats in order to achieve an outcome that better favours the independent candidates. And we submit, Justices, that on that, the independent candidates have brought an application in circumstances where the applicant really represents 29 separate independent candidates who intend or are contemplating running for elections. It stands to reason that their motive or their underlying impetus for it would be to advance the rights of independent candidates. But we submit there's no basis for an infringement. There's no demonstration that the legislative measures that have been adopted in the Amendment Act that allow for independent candidates to stand for public office and, if elected, to hold that office, actually results in any denial of those rights. and particularly not when one looks at the threshold of the reasonable pursuit of that right, as this court said in New National some years ago. So, members of the court, that just brings me then to the last of the issues I intended addressing on the question of remedy, and that is, we say in the first instance that no case has been made out for either a rationality challenge or a rights infringement, and that ought to be the end of the matter. If the court is not with us, then we submit that the high watermark of the relief that the applicants can get from this court is a declaration of constitutional invalidity together with a suspension. We submit that none of the interim relief sought is in fact appropriate, and we say this because some of the options that have been raised are options that were considered in the course of the engagement on this. They were rejected, and in those circumstances we submit that it would be overreach for this court to grant a reading in order in the terms sought. Members of the court, those are my submissions. I think I'm ahead of schedule on the time.
Thank you very much. Justice Rogers.
Yes, Ms. Pillay. Assuming that both the 200-200 split...
I'm sorry, Justice Rogers. We are at 24 minutes past 1. I think we are aiming to take lunch at 1:30. So the question is whether we start the questions or we just take the lunch break and come back. Maybe you should ask the question and then we'll see. Okay, go ahead.
Assuming for the moment that the statistics showed that both a 200-200 split and a 350-50 split resulted in no risk of overhang that the court should concern itself with, something very tiny like 0.13%. But it also shows that whereas an independent candidate competing for one of the regional seats needs to win 80,000 votes to get elected, whereas a political party contesting for the 200 compensatory seats only needs to get, say, 45,000 votes.
Yes.
From one voter, which gets multiplied by 2, effectively. Would that be a violation of Section 19 and free and fair elections?
Yes. Justice Rogers, it would depend on the facts around it, and if I could perhaps just...
Well, in general, would a system be fair which said independent candidates must get double the number of votes of a political party to be elected?
Not at all.
And if the effect of the system is that, then presumably the answer must be the same, even if it doesn't say so in terms. And that is the effect of the 200-200 split in relation to the 200 compensatory seats.
Yes.
Mr. Badnader emphasized, well, the political parties and the independents are on exactly the same footing when it comes to the 200
regional seats,
but that isn't the concern.
Yes.
The concern is the disproportionate number of votes they have to get compared to political parties to contest for their 200 share of the seats.
Yes.
On the face of it, I think that would strike the ordinary person. There's something wrong there.
Yes, I accept that, Justice Rogers.
And if there's something wrong there, then it must be because it is something that is contrary to the requirement in Section 19 of free political choices and the right to stand in free and fair elections.
Yes.
So isn't there, therefore, as it were, a self-evident violation or limitation on Section 19? And the question becomes, can the limitation be justified by Parliament's concern over what might be regarded as a relatively small risk of a one-seat overhang based on the 2014 election results?
Yes, yes. So there are a couple of answers to that, Justice Rogers. Perhaps let me start by saying this. The starting point I would submit in engaging with those propositions would be what is the evidence before this court. And what is the evidence before this court on that? And on the evidence based on the Atkins report, we have a risk of overhang, I would submit, that goes between 6% to 15.08%, I think it is. And I would submit on the papers as filed, that certainly doesn't demonstrate a negligible risk.
Well, it's a risk on one scenario.
Correct.
For a minor party.
That is so, that is so. But of course, based on what this court said in New National on the test that has to be satisfied by an applicant coming to court seeking to allege an infringement of a right, I would submit on the evidence that it would have been incumbent on the applicant to demonstrate that there is in fact a far greater risk, and these are the significant consequences of it.
But isn't the greater risk or the greater harm to the freeness and fairness of elections simply that independent candidates have to get double the number of votes in order to get elected? I appreciate that for the 200 regional seats the same applies to the political parties, but I'm concerned with, because we are concerned with whether the political party should have 200 compensatory seats or only 50.
Yes.
So the question is why political parties, as against independent candidates, should be favoured in that way.
Yes.
And the justification put up for it is this risk of a one-seat overhang. Now, is that, I know you describe it in your submissions as a grave or a dire risk. I must say, not being in the political world and the hustings, I wasn't really, it didn't strike me quite at that level. But assuming it exists, is it a danger and a risk that justifies what is the certain outcome?
Yes.
That independent candidates need so many more votes in order to be elected than political parties? Because the one is a certain outcome.
Yes.
The other is a small possibility on certain scenarios.
Yes, yes. Justice Rogers, let me answer it this way. The first is that once we're out of the envelope of the 400 seats, which is what certainly my understanding of what the consequence of the overhang is, what we then have is a consequence that says we're out of the realm of 400 seats, we can't certify the election, and it's a consequence that is irremediable on the papers. And I would submit that if the court is to reach a justification inquiry on that, those are the factors that ought to weigh quite heavily. It then doesn't become simply a question of it's a margin of a one-seat differential between both the models, and the one put up by the applicants addresses the position of independent candidates.
I must say, it doesn't strike me as beyond the wit of human beings to resolve in that situation who loses out the one seat. In fact, the Atkins report seems to indicate quite precisely how that lost seat will feature and who loses it. So it seems to me that the current system does allow for the allocation of the 400 seats. Perhaps the IEC's counsel, when he makes submissions after lunch, can explain whether it is really as serious as not certifying the elections.
Yes.
But it surely must be possible that if there's one seat hanging around, that you can determine who loses that seat.
Yes.
But, for example, who got the least number of... there must be some relatively simple way, I would have thought, of saying who falls off the bus.
Yeah. Justice Rogers, sorry.
No, but that's something that perhaps can be considered by one of the other counsel.
Thank you. I can only answer based on the evidence that certainly that Parliament and the IEC has put up on this point. I think the Minister has as well, that they do say it's then an irremediable consequence if that happens. So I do make that point.
I don't see any other hand from my colleagues. So we will take the lunch adjournment now. I just mentioned that counsel for the IEC did indicate in chambers that he was here in case we have questions for him. So we will see when we come back. If we have questions, we'll allow him to deal with them.
Thank you.
We are going to take the lunch adjournment now. On my watch, we are at 28 minutes to 2. I propose to make the lunch adjournment 40 minutes because sometimes if it's 30 minutes, it's too short. 40 minutes. So we will resume at 2:10.
Thank you.
The court adjourns.
you don't need anybody to tell you that. It's quite clear from the Electoral Act that if that problem were to arise, there is no statutory mechanism to deal with it. The third issue that
is the effect of that that since the IEC can only perform functions and exercise powers that the Constitution and the law confer on them, if neither the Constitution nor the statute gives its power to deal with that situation, it would not have the power
to
Is
certify.
that what it means?
That's exactly, that takes me to my next point.
Yes.
So I'm not debating, because that's not an issue for the IEC to deal with, the acceptability of a 1% or 2% or 5% risk of overhang. That's for the court to deal with having regard to submissions. But what I can place on record is that should that, and this is the question that Justice Theron had raised, should that risk eventuate, however small it might be, its consequence, and they've asked me to put 3 issues before this court. The first is that they cannot certify the election. That's the known consequence. The second is an unknown consequence. What will the public reaction be? How is the public going to react to what will then be a failed election? And the third is they ask me to simply place on record that as we sit here today, 1 seat may seem like 1 seat, not much. At the end of an election, 1 seat may determine who forms the government or who doesn't form the government. The third point they want me to simply point to, and this goes again to, I think, a debate which Justice Rogers had with Ms. Pillay, and that is about the inequality of votes. Now, this is dealt with, and I'm not going to argue it, I'm simply going to point out, it's dealt with at paragraph 23.2 of the IEC submissions, where they simply say that the 85,000 takes into account the total count on both ballots. So, for example, assuming a voter on the regional ballot votes for a party and chooses to vote for the same party on the compensatory ballot, then it means that one person has given that party 2 votes. But they say that's an assumption you can't make, because patterns have illustrated that a person voting on one ballot may vote differently on another ballot. So to simply say that it's half the number is statistically inaccurate, but I'm not going to argue the point because it's explained fully at para 23.2 of our heads of argument.
But Atkins' point would hold true in accordance with his assumption, which is that a person who votes for a party at the in the regional ballot votes the same for the same party in the on that basis there is this substantial inequality.
True. And as I said, I'm going to remain true to what I can and can't do. I'm not going to argue any point. That assumption is dealt with at 23.2.5 of our submissions.
Yes, I can understand that when one is voting for a provincial legislature on the one hand and voting for the National Assembly on the other, you might say, well, I'll go for this party for the province, but that party for the country. But when all you're doing is voting for the National Assembly, it doesn't seem a very high likelihood that a person will say, well, for that seat I'll vote for that party, and for the other one I'll vote.
That may well be in the arena of speculation, which the IEC doesn't want to embark on. What it does point out is that it's an assumption which may not be justified. There's no evidence to justify the assumption.
Can I just ask you on the overhang and the absence of a mechanism? Of course, that presupposes that if there's a problem that this court needs to address in terms of the potential inequality of the number of votes required to attain a seat, the problem of overhang, and you may need to take instructions on this, but I was just thinking about it during the lunchtime. Once you've done all the calculations and you've stripped out the forfeited seats and reached the end point, your overhang problem is that there are political parties that have won 400, well, let's call it 401 seats, and you only have 400 to allocate. If one then said that the party that falls off the bus, in other words, who loses the seat, is the party with the lowest remainder votes, because once the final calculations are done, there's a final quota, and that quota will give each party that wins a seat, and then there will be remainder votes for each of them. And if you simply say the person with the smallest number of remainder votes loses the overhang seat, it doesn't seem to me inherently to advantage or disadvantage anybody, because the smallest remainder votes could be the largest party or the smallest party.
Parliament may say that, this court may say that, the IEC doesn't have the power to say that.
I'm just saying, I would be interested to know whether a solution, there may be other solutions, but that just seemed to me a straightforward one. You've got to cut the Gordian knot, and that's one way to do it. So it seems to me the obvious way to do it.
There are two reasons I want to answer to the question. The first is it hasn't been canvassed on the papers, and the second is my client is not going to get involved in it. It's either empowered to do something or is not empowered to do something. And I'm not avoiding the question. I'm staying within my lane.
Well, I wanted to say earlier on, you certainly are allowed to clarify, so because I thought you seemed to be too concerned not to be seen to be doing something that you had said you would not do. So clarifications might be important, particularly from the IEC.
I'm perfectly happy to clarify. And my answer in clarification to Justice Rogers' question is the IEC's stance is simply that it has no statutory authority to do so. In other words, there may be different permutations, but if those permutations exist, it's either for Parliament or this court to pronounce on. From the IEC's perspective, it can't stray outside of what it's permitted to do, and to go into that exercise would require it to do so. So I'm not hiding from it. My clarification is it doesn't have the power to do so.
And this wouldn't fall under incidental powers or anything like that?
It's substantive. It determines the outcome of the seat.
It's too important to fall under that.
It tallies up to see who gets the seat. It doesn't make a policy determination on whether it should go one way or the other.
Yes.
That's not inherent powers.
Okay. Okay, all right. Thank you. Thank you. Thank you. I think then, yes.
Chief Justice, I just have one very brief submission.
Yes, you are in reply now. Are you going to be the only one replying?
Yes, the only one.
Okay.
And I don't want to go through the debate again.
Yeah, and that would be
but the
10 minutes.
deviation of one seat due to the fractions is acceptable for the respondents. That's acceptable for them. The risk of overhang is restricted to one seat. So it's the same. Third submission, they say that deviation caused by overhang is of a different nature because of the 401 problem. Now, obviously the 401 problem has been dealt with at the local government level because we have that item 16 of the Structures Act, and it must be curable. I then would like to refer the court to just one case about this court's remedial powers, which is the Economic Freedom Fighters and Others versus Speaker of the National Assembly, which is 2018, Volume 2, South African Law Reports 571, Constitutional Court at paragraph 211. And you will all be familiar with that passage there, because it says that the power to grant a just and equitable order is so wide and flexible that it allows this court to formulate an order that does not follow the prayers in a notice of motion or some other pleading. This power enables courts to address the real dispute between the parties by requiring them to take steps aimed at making their conduct to be consistent with the Constitution. And it then goes to Hoërskool Ermelo, the judgment of Moseneke DCJ, that goes on. This ample and flexible remedial jurisdiction in constitutional disputes permits a court to forge an order that would place substance above mere form by identifying the actual underlying dispute between the parties and by requiring the parties to take steps directed at resolving the dispute in a manner consistent with constitutional requirements. In several cases, this court has found it fair to fashion orders to facilitate substantive resolution of underlying disputes between the parties. Sometimes orders of this class take the form of structural interdicts and so on. This approach is valuable and advances constitutional justice, particularly by ensuring that the parties themselves become part of the solution. Now, there's a variety of ways of dealing with a 401 problem. Incidentally, that wasn't squarely raised on the papers, 401, as a defense. The word 401 doesn't appear in any affidavit. So there's the solution that Justice Rogers has just mentioned to the IEC, to which there's no answer. Isn't that the obvious solution? There's, of course, other solutions. The court may, in its order, direct the IEC, if necessary, to provide an item similar to the one that exists in the Structures Act, to deal with this monster of overhang, this incurable beast, which we know is not incurable because it has been dealt with at the local government level. Something similar should be capable of being devised fairly easily. That's the one submission. Was that longer than one, perhaps, Chief Justice? And I don't think we don't have any further submissions.
Just a brief question, Mr. Duval. You indicated that there are two types of risks. The one that comes from the rounding off and where the loss of a seat may occur, and the other from overhang. But it's been suggested that the one is unavoidable because it's inherently built into the process, and the other is avoidable. So what would you say if one had a choice that you can't avoid the unavoidable risk, but if you can avoid the risk,
yes,
then by all means do so?
No, one can certainly avoid the risk if you want to halve the value of the independence vote. It's as simple as it is. It's a balancing act, of course. If you want to go for 200, the risk of overhang is reduced.
But do you accept, and I think Counsel for Parliament pointed out to your written submissions, I think that you accept that on the 200 split, for all intents and purposes, there is no risk of an overhang.
Yes. I wouldn't say, I mean, of course, that may well be the case at 150, at 100 as well to some extent, but we didn't go there.
Yeah.
We pegged it at 50 because that struck the sweet spot for us. But
yeah,
the main submission, Chief Justice, is that it's a simple technical glitch in the system that makes it wants to allocate 401 seats.
yes,
That glitch is easily cured,
yes,
as we know from the Structures Act. So there's no reason why the substantive dispute between the parties, which is the impairment of an important constitutional right, Section 19, why we should now all, no, sorry, I meant rephrase, that should be sacrificed because as things stand, there is no provision dealing with it in the Electoral Act.
yes. Thank you. There's a further question.
Is it
Justice
correct to
Kippers?
say, you are correct, Mr. De Waal, when you say that there is no reference to the figure 401 in the papers?
Yes.
But it's clearly stated in paragraph 34 of the Commission's affidavit. I unfortunately don't have the reference on the page because I've been working from the unnumbered record. But if you can just tell me where...
Yes.
What page number is that on paragraph 34? of the IEC's affidavit. There it is stated that the number of compensatory, a reduction in the number of compensatory seats poses a risk of overhang which may result in proportionality in general not being achieved in the National Assembly and the Commission not being able to declare the results of an election. Is that not a 401, not argument, statement? Isn't the Commission saying there we would not be able to declare the results because we will have, in effect, we will have 401 seats?
I accept that one can read it like that. The problem really was when you read this affidavit, you would have expected them to say something like this. There is this 401 problem. We have dealt with the 401 problem at the local government level through item 16. We don't have a similar mechanism here. That's our problem. And if they said that, Justice Schippers, I'm a bit hesitant because then we may have filed a replying affidavit and we've said, here's the formula, here's the item for you that we drafted, but we don't want to draft it. We want, because then there's all the major surgery to the statute and so on. It's for them to come up with something like item 16 in order to prevent this violation, the serious violation of the right to vote, equality of the vote, in order to cure this problem. And again, it's not something that the legislature should involve itself. We don't have the time, I accept that. We may not have the time, let me rather put it like that. But it's incumbent on the IEC in this, along the EFF line, to provide the court with something similar to item 16, which would deal with this problem so that it goes away and the court decides the substance of the dispute between the parties. That's the submission.
Thank you, Mr. Javal. We'll now have the clerk call the second matter. I'm not leaving out anybody who was still to... Yeah, okay, all right. Please call the second matter. Not everybody may have recorded their appearances earlier. So I think let's just do the appearances in regard to this matter so they will appear on the record. Let's do the appearances first.
May it please the Court, Chief Justice, I appear for the applicant, One Movement South Africa,
Thank
together
you.
with my learned friends Ms. Mudli, Ms. Mdleche, and Mr. Suleiman.
Thank you.
As it pleases the Court, Chief Justice, I appear for the President, who is abiding, and for the Minister of Home Affairs, together with my learned friends Mr. Nasseruddin and Mr. De Beer.
Thank you.
As it pleases the Court, I appear for Parliament in this matter too, together with Mr. Kalela and Mr. Sullick.
Thank you.
Chief Justice, Justices, I appear on behalf of the Amicus Curiae Rivonia Circle, together with Ms. Maharaj Pillay and Ms. Creyer.
Thank you.
May it please the Court, Justices. I appear for the IEC in the same capacity as previous.
Thank you. Okay.
May it please the Court, Chief Justice.
Thank you. Your 30 minutes starts now.
Thank you. OSA is an association and a collection of individuals who work with independent candidates. They have been participating in the electoral reform process, and they have made submissions to Parliament and to the President, which I will turn to shortly, with respect to the effects of this Electoral Act on them. So when it approaches the court, it is here in its capacity as representing its interests of its members and the broader public. The first challenge that it brings is in terms of Section 19 and Section 9 of the Bill of Rights that's set out at paragraph 3 of our heads of argument. The first challenge is dealt with at paragraph 44 of our heads of argument. And the challenge is a fundamental infringement of rights. It's not a challenge based on irrationality. It is not a challenge based on reasonableness. And in that fundamental infringement of rights, the onus and the duty to present evidence and to justify decisions remains on Parliament. And I know that we deal with this so often that we often forget what the elements are, but that is the Bill of Rights may only be limited in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors: the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relationship between the limitation and its purpose, and less restrictive means to achieve its purpose. Now, to demonstrate the position that the applicant's members find themselves in, I need to create a picture for the court, because what the Amendment Act does, the Electoral Act does, is it creates constituencies, effectively constituencies, the size of a province. So it is all very well to say, for the Minister and for Parliament to say, we've linked it to the size of a province. But in real terms, what does that mean for independent candidates who operate individually? And those were the interests they were putting before Parliament. In real terms, and we're grateful to the IEC for providing us the statistics, yes. We deal with this at, pardon me, sorry, I don't have an index bundle, at page 28 of our heads of argument. So in the Eastern Cape, for a member of OSA to demonstrate signature support of 15%, it will have to obtain the equivalent of 3 signatures in each of 4,869 districts. Similarly, KwaZulu-Natal, where I come from, an independent candidate would have to obtain the equivalent of 3 signatures from votes in each of 4,972 voting districts. What does this demonstrate? This demonstrates the basis upon which OSA participated in the parliamentary process. They made submissions to Parliament on the 21st of February, which we don't need to go to, and they made submissions to Parliament on the 16th of September 2022. That appears as Annexure C to the founding affidavit, page 116. and it raised squarely the issue of the signature requirement. And it said political parties are only required to obtain 1,000 signatures. That's 117. It did so under the heading Practical Implications. It said, in the last national election, 17.4 million people voted for 400 representatives. At the time, what was proposed was a 30% quota. And that equated at that time to a signature requirement of 12,900. Nevertheless, also said, on behalf of its members, we are different. This is a barrier to entry. And they said, page 117, first, second, third, fourth paragraph. Firstly, political parties are only required to obtain 1,000 signatures in comparison to the signatures required by independent candidates. This is an unfair differentiation, as the signature requirement is supposed to serve the same legitimate purpose for all those contesting elections. Yet, there is a disproportionately high threshold that is placed on independent candidates and not on political parties. They go on to say, this is a barrier to entry, and they did make the accusation specifically targeted to keep independent candidates out of the system. They made the complaint, this is a violation of their Section 19 rights. They made the complaint, this is an unjustifiable limitation of our rights. We know from the record that upon advice presented to the minister, the quota was subsequently reduced. When OSA submitted its submissions to the President on the 28th of March, 2023, that's Annexure D, at page 121 of the record. And I'm referring to page 122. The signature requirement is dealt with again. By now, the parliamentary process was over, and OSA was trying to intervene at the stage to persuade the President not to sign. It records, while we appreciate that the purpose of imposing a signature requirement is to ensure a serious intention, in the next paragraph, of contesting elections and limit the number of frivolous candidates on the ballot, the figure that has been proposed is unjustifiably high and is a barrier to entry for new entrants, in violation of independent candidates' Section 19 rights to stand for public office. And it is again the complaint. To date, 1,000 signatures has been effective in ensuring that all those contesting an election are legitimate contestants who can garner sufficient support. And the complaint was the IEC and Parliament have yet to demonstrate that this threshold has not been effective to date. How does the committee justify an additional 10 to 13,000 signatures for independent candidates and new political parties to achieve the same objective, that 1,000 signatures have previously sufficed? So it's on that basis that when the Act was passed, reflecting this increase, Common Cause, 11,000 to 14,000 signatures, that's 1,000 to 1,800% increase. Common Cause, just at the National Assembly level, also came to court to assert its rights and claimed that this is a disproportionate impact. What was the justification that came through from Parliament? Yes, pardon me, it's an increase of between 1,000 and 1,400%, and for provincial elections, it's an increase of between 800 to 1,800%. Now, self-evidently, that's a dramatic increase in having to demonstrate voter support and in having to demonstrate that you're serious and that you're not frivolous, because that has been the underlying explanation. Yes, the ballot issue was added, and the freeness and fairness of elections was added subsequently in affidavits. But this is the explanation from Parliament. I refer the Court to page 64 of our heads of argument. Parliament's explanation for this new contestation requirement is, it ensures that neither political parties nor independent candidates contest an election frivolously in order to make a point or to achieve a purpose other than to represent their constituents in elected office. The contestation threshold is aimed at the seriousness of a political party and independent candidate to contest an election. And then, in the answering affidavit put up by the IEC, the Chapter 9 institution, they put up statistics to say the number of political parties has increased over time. Political parties, not independent candidates. Including in the numbers of political parties who have gained representation, some frivolous participation, but there's no indication from the IEC as to what percentage or what reason that could have been. Nor is there any reliable prediction from the IEC as to what might be expected as frivolous participation in future elections. So with respect to the explanation put up by the IEC and Parliament, it seems clear that the precipitating factor for this signature requirement was the new reality in this country, that independent candidates had to stand and had to be permitted to stand for public office. And apart from the limited participation of independent candidates in local government elections, none of the respondents have demonstrated any forecast of what might be suggested as independent candidates participating in the National Assembly. Nevertheless, it would seem from the explanation from the IEC that there are too many political parties who participate without obtaining a seat. And the equation and the reasoning has been, you did not obtain a seat, you were unsuccessful, therefore you had no support, therefore we need to impose a signature requirement. And that, with respect, is a wrong approach to the Section 19(3)(b) rights. Firstly, that right has no internal limitation. It's available to all adult citizens. Secondly, it gives effect to fundamental standards in Section 1 of our Constitution. Multi-party democracy, accountable and open government. The people who will vote for members of OSA are people who want their representatives, directly elected representatives, to answer to them. And that is the difference. And despite this court, despite our courts recognizing in CALM and others versus Electoral Commission, that there are obvious differences between an independent party and a independent candidate, please pardon me, and a political party, in terms of resources, in terms of participating in the electoral process. No thought or consideration was given by Parliament or the IEC to the position occupied by independent candidates. Now we come back to what the IEC says. That is at page 511. It's at page 511. But I refer the court to page 536, more importantly, 535. No, please bear with me, Chief Justice, it is late in the day, I have the wrong page. Yes, 522.
522.
Yes. In the early national elections, political participation was limited, and what the IEC tells us that in the last 2 decades, the parties have gone from 21 to 26, 26 to 29, and then to 48. And what they have demonstrated is that the percentage of those who were not successful has increased. The IEC accepts on page 524 that there are currently 332 parties registered to participate. If all of them, and these are registered parties, they registered with 1,000 signatures. If all of them decided to participate, the next election is impossible. So that's at the extreme end. But when it comes to what it will do if the applicant is granted relief as it seeks in this application, that's dealt with in 546 to 548. Nowhere in here is there any indication that elections will be objectively impossible to hold. Yes, they have planned on a single-page ballot with 98 names. They say that they would have to change the size and layout of the ballot, and that at paragraph 68, if the amendment of the signatures required that OSA seeks, they say it could have very profound implications for the Commission's preparation. It may increase substantially. It is difficult to predict the impact, but it is possible that the number would require a redesign of ballots.
I'm sorry, you are at paragraph 68 at the moment, is that correct?
Yes.
At page 547.
Page 547.
Okay. Thank you.
Over the page, they deal with the fact that additional vote counters may be required. And of course, they talk about costs. But nowhere is there any suggestion that the introduction of independent candidates into our election system, A, is responsible for any of those past statistics, and B, will be frivolous candidates, or C, not serious candidates. In any event, what the IEC and Parliament does is they rely on not successful, not supported, to equate to not serious about the elections. And that simply is the wrong premise upon which to approach an essential guarantee in our country, the very double helix of our country, which is a participatory democracy.
I'm sorry. Are you able to? I think that there may be colleagues who didn't get the paginated record. I think let's the paragraph numbers that you have given.
Yes,
let's give them so
Again?
that they can locate them without the paginated record.
Sure. The paragraph numbers are at, yes, where they talk about the practical imperatives. It goes from paragraph 29 to 30 to 31 to 32.
You want to identify first whose affidavit that you are
Yes,
referring
that
to?
is the affidavit of Mr. Mamabolo. That brings me then, Chief Justice, to the position at present in our law. The position at present is that Section 26 of the Electoral Act sets out requirements for parties to contest election. And there are two requirements for political parties. One, you be registered. Those are regulations prescribed under the Electoral Amendment Act, which require you to obtain 1,000 signatures. And two, that you have submitted a list of candidates that you will put up as your party list. That is the contestation requirement in our law currently for political parties. What has now been added in our respectful submission through the introduction of under submission of lists of candidates is a pre-election barrier. It's self-evident that if the 11,000 to 14,000 signatures are not obtained, you don't enter the race. The question does not turn on the rationality of that. The question turns on the impact of the fundamental rights and the core values of our Constitution. The question does not turn on the reasonableness of that. The question is this Amendment Act consistent with the fundamental rights in the Constitution? And OSA submits that it is not. This is a disproportionate impact. According to Section 26 on its terms, the contestation requirements for the 2024 elections are limited to 1,000 signatures for political parties. And we submit, and we deal with this at page 31 of our heads of argument, that when it comes to the limitations analysis, irrespective of rationality and legitimate government objective, the question of less restrictive means to achieve the government purpose of a manageable ballot, a manageable election, something that is not too expensive, as it affects single individuals who will be directly accountable to citizens in this country. That was not at all considered. And on that point alone, we submit that the respondents have failed to justify the limitation, the self-evident limitation of rights. Insofar as Section 19(3) says you have a right to stand for political office, it must follow, given the centrality of equality in our Constitution, that when you enter the race, you do so on a level playing field and on equal terms. The fact that you have equalized up and added 12,000 signatures to new participants does not assist the state in this endeavor. If anything, it just shows that the burden's been spread. But from the perspective of my client, we say this is an unjustifiable limitation. Those are our submissions. Oh, secondly, the final last submission, that Parliament and the Minister, with the best will in the world, have not demonstrated on these papers a serious consideration of the impact of individual candidates. They say they considered the submissions. They have not considered the practical implications of independent candidates having to meet percentage of a quota of an entire province. And that's why we say, at the very least, the less restrictive means test was not even considered. And we submit that the existing Section 26 of the Electoral Act, which specifies the contestation requirements for political parties, is suitable relief to be granted in these circumstances. Time is upon us. As Justice O'Regan noted in Richter, our democracy and our elections work. We can't press a pause button on fundamental rights. Yes, we can achieve electoral reform later, but what happens in the 2024 elections determines on who gets to consider that electoral reform. And if independent candidates are prevented through an unreasonable, disproportionate barrier, which they say, this what they say on oath, this is that barrier. They've said it to everybody. But what that means is that for the purposes of this direct access urgent application, we submit that the court is empowered in those circumstances to read in the signature requirement. It is the existing standard. We're not asking the court to create new legislation or take over the role of Parliament. It is an existing standard for political parties to contest the elections. Chief Justice, insofar as the second aspect of the case is concerned, in the light of the joint report, which indicates that the Atkins report can offer no commentary on proportional representation in the National Assembly and on provincial legislations, I just wish to make this point. Firstly, paragraph 134 of my heads of argument have been misinterpreted, and I wish to correct that, please. Yes, in paragraph 134 at page 42, where we wrote, not my client, we wrote, the IEC contends that the recalculation ensures that candidates who are not eligible to hold a seat or who have chosen to vacate a seat cannot be allowed to influence the outcome of the recalculation. On its own, this principle is unobjectionable. Unfortunately, that sentence has been interpreted to suggest by some of the respondents that OSA agrees with the application of the recalculation process. That is not so, and I apologize for any confusion, but the purpose of delivering this challenge was to demonstrate that in provinces is a remedy. I will stop if I'm...
Yes, you will stop, but I'm sure there are a few of us who are going to ask you that question. So
Right, thank you.
deal with it under questions, yeah.
Thank you.
Yeah, deal with it.
Okay. The limited purpose for which the second Atkins report was presented was to deal with the effect of the recalculation. All the recalculation does is it excludes a block of votes. Yes, the independent candidates get to retain their seats. The seat quota is recalculated, and Atkins' undisputed mathematics and outcomes reflect a disproportionately high allocation to larger political parties.
Yes, thank you. I don't see any. Oh, Justice Theron.
Thank you, Chief Justice. Ms. Gabriel, the applicant contends that the recalculation method unfairly advantages parties with a larger share of the votes and therefore results in a bias. And the applicant also says that what this means is that votes cast for larger parties count more. Are all the parties in agreement with that?
No. That's disputed on the papers.
What is the bias that the applicant contends?
Well, if I may explain it as simply as possible, because I'm also not a maths person. Independent candidates, the recalculation only happens when independent candidates are involved, unless a political party submits fewer names on its candidate list. If an independent candidate has to forfeit a seat or assume only one seat or vacates, what happens in this process, and this is at provincial level, which doesn't have a second ballot, those votes are excluded. So all the votes for independent candidates in that province are taken out of the equation as a block. And the seats are recalculated, a different quota is attached, and on that basis the remainder seats are allocated. What we suggest and submit is that a proportional allocation of those votes would be according to the least remainders. So
I didn't understand it to be that all the votes, the entire block is taken out.
Pardon? Sorry, Justice Turan.
Yes, I didn't understand that the proposed system would work the way you are submitting, Ms. Gabriel. But I may be wrong, and I'm sure the parties will clarify as we go along.
I'm just checking my note. Yes, so Atkins says all the votes that political parties gained are used again, minus the independent candidate votes and their seats, although they retain their seats. A new quota per seat is determined and seat allocation is made. Now, obviously, those who voted for independent candidates and who didn't make the initial quota, those votes don't count. But in the recalculation process, all the independent candidate votes are excluded, and the recalculation results in a reduced quota for the remainder seats. I'm not sure, Justice Turan.
You heard part of the argument in the earlier case and the reference to section 461G as well as 106 of the Constitution, which says that we must have an electoral system that results, and I emphasize the word in general, in proportional representation. What does that mean in practical terms, in general?
All I have is the minority judgment to go by in the case cited in our heads, and that is a party's share of the seats should be in proportion to the votes that it receives. So, does the second Atkins report deal with the in general proportional representation? No, it does not. What the applicant's case is that this gives a different weight to the value of votes for independent candidates. On that there is disagreement, because the contention from the state respondents are no, because the vote came in and you got a seat. And so the purpose of that vote was achieved. But what we are saying is when one independent candidate leaves, because he can't hold more than one seat, or vacates, all the qualifying independent candidate votes are removed from the equation. Whereas the system, the natural system, is to allocate according to the remainder of votes in the highest surplus and in that order.
Is the applicant saying that the recalculation method in the event of a vacancy does not have the effect of an in general proportional representation?
The submission is it results in further disproportion in an already disproportional system.
In respect of the signature requirement, does it not, the applicant's argument is that the signature requirements in respect of independence is far too onerous and it represents an unfair barrier. Would that argument also not hold water for the smaller political parties?
Yes, yes, and that is the basis on which...
But the smaller political parties are not here.
Well, we have, if this court finds that this is a disproportionate impact for elections that are to happen literally around the corner, then it's my submission that the equivalent provision of Section 27 and its unconstitutionality cannot be ignored. Now, we didn't ask for that relief, but this court does have the power to declare the equivalent provision unconstitutional.
Wouldn't that be going too far, Ms. Gabriel? Anyway, you don't need to answer that question.
In terms of separation of powers, my difficulty conceptually is this. If you come to a finding that Section 31 is unconstitutional, it's exactly the same ratio and requirement that is applied to new political parties who, as they say in CALM, are trying to break into the political landscape. This impacts on them equally. If you find as a matter of justification that this limitation has not been justified, I do not see how this court can ignore the parallel unconstitutionality in Section 27 signature requirement.
Now, we get to an aspect that I find even more concerning, and that is remedy. And I know the applicants say it's a small reading in, but the effect of that, would it be appropriate for elections to go ahead knowing that it might be unconstitutional? What do we do?
We say the only remedy to grant in these circumstances is the reading in remedy as we seek. And it is important for two reasons. This is the first time independent candidates will be competing for an election. We've had no experience of this before. Everybody is on tenterhooks. It takes time. Pre-electoral processes takes time. Getting 12 to 14,000 signatures takes time. So there is that to consider, and that is why OSA has said, we're not asking for you to write the law, we're asking for you to apply the existing standard.
There is no standard, Ms. Gabriel, because this is the first time independents will be participating at that level.
Well, the contestation standard of 1,000 signatures in section 2026.
This court, if it had to do that, would be imposing a voting regime. And isn't that clearly a breach of separation of powers?
This court is not prevented from granting effective relief where the circumstances require it.
I agree with you, and I'm sorry to interrupt you, but effective relief does not, the power to grant effective relief does not entitle this court to breach separation of powers.
I accept that, and we also must accept that. But the problem with a suspension without an interim reading in is the election will be over. If it is suspended for 3 years, then that's the lifespan, anyway, of the Electoral Act. If the independent candidates do not get in now, then the people who are determining the amendments to electoral reform in our Constitution will not be in, and it will be too late.
What is the applicant saying, Ms. Gabriel? That there's not enough time before the elections to remedy any defects that there may be? If this court was with the applicant and inclined to suspend the declaration of invalidity, would Parliament have enough time to remedy the defects? And would this period have to include time for the President to complete his role in the legislative process? Is that possible?
I'm sorry, I'm a bit lost, Justice Turan. The applicant? I'm not sure where you were referring to.
If the court is with the applicant,
yes,
is there enough time before the elections to remedy any defects that there might be if this court were to find that there are defects and that the requirements are unconstitutional?
Well, the state respondents say there isn't enough time.
Asking the applicants, Ms. Gabriel.
Well, nominations have to be in according to the current timetable by February 2024. So that is September, October, November, December, January, February. 6 months. I do not see how a legislative amendment with the President's participation could be accomplished in 6 months. The pre-election period is important to meet the requirement to stand in the election. And so suspending will not bring effective relief in our submission.
Isn't this court once again being placed in the difficulty of having to find solutions which should be found in Parliament?
That is why we need direct accountability in Parliament. That is what OSA says. A participatory and a representative democracy. So we don't have...
You want direct accountability in Parliament, but you are coming here.
This court is the ultimate guardian of the Constitution, and those are our submissions.
Thank you, Ms. Gabriel. Thank you, Chief Justice.
I think one of the respondents says what you say is a limitation in terms of the signature requirements. is not a limitation but regulation. What do you say to that?
A regulation of the Electoral Act.
Regulation of elections, of their rights, regulation of their right to vote.
Well,
you know, you have the right to strike under the Labor Relations Act, and there's provision in the Constitution that Parliament may regulate it. And I think one of the respondents says it's not a limitation, it's Parliament is regulating that right.
We respectfully differ on that.
What is the difference between a limitation and a regulation?
We can understand regulating in a general capacity, timetables, schedules, registration requirements. But when it comes down to imposing conditions upon the participation of actors that go way beyond what is provided for in Section 19.3, there is no contestation requirement in Section 19.3.
And what do you say about what one or more of the respondents also say, maybe by implication, that if you lower the requirement of signatures to 1,000 in respect of individuals, you are going to make it very difficult for the IEC to manage the long list of candidates in the ballot paper that they might end up with.
Chief Justice, in our submission, an active and vibrant democracy requires the participation of as many contestants as possible in an election. Nevertheless, there are constraints, we accept that, on the Independent Electoral Commission. But on their own statistics, that increase in participation has not been significant. It's the increase in what they say, parties without support, that has been significant. Now, all of this is hypothetical, that it may become more manageable, but the IEC has filed an affidavit in this court, and it has said, this is what we would need to do, and those are practical problems.
But to the extent that the IEC might have said in their answering affidavit, this will create the following practical problems. If we lower the signature requirement to 1,000, the fact of the matter is that you haven't responded to say those explanations or those difficulties are not true or are not justified, have you?
We say it's self-evident. And we've dealt with that we didn't say self-evident, but we have dealt with it in our heads of argument.
Yeah, but is that the place to deal with them?
Well, we didn't
If they
file...
say there are practical problems, you need an affidavit to deal with that, isn't it?
Well, therein lies the conundrum for direct access applications to this court, because there isn't provision for applying affidavit.
No, but you can apply to court to say what the respondent has filed calls for a reply from me. I'm asking the court to grant me leave to reply.
Well, in this sense, we have responded, Chief Justice, and respectfully so, by saying, when you look at what the IEC has said, none of it demonstrates that as a matter of law, it will be objectively impossible. All the IEC says, we've got a ballot for 98, that'll take 98 names. We haven't currently planned for a second page. They don't say we can't do a second page. So just on their affidavit, we can accept that it might be practically difficult, but certainly not unmanageable.
Justice Matopo.
Ms. Gabriel, I just want to test the IEC stance on the 1,000 rands. Sorry, it's late in the day.
It's late in the day. It's Justice Matopo.
On the number 1,000. In one of the papers, I have seen that there are about 332 or 31
Registered.
parties. If one were to postulate a scenario where those parties, all of them, were to qualify to contest the elections. Now, the problem that the IEC envisages, how is the IEC going to deal with them? Because sitting here, we don't have the crystal ball to look into the future and say, those parties may not be able to contest the elections. If they do, and the IEC had said, we can't have the independents participating because there's going to be some logistical problems, i.e., there's going to be 2 pages of the ballots. Now, with 300 now, definitely you would be required to have 2 pages, if not 3 pages of the ballot. Now, doesn't that gives a different color to the IEC submissions, or am I reading something that is not there?
I think we can extrapolate this. The fact that the political parties are registered means they've met the contestation requirements. The fact that there have been 331 demonstrates that those who register to contest the elections will not necessarily participate in the elections. I think that statistic counts against the IEC, because the speculation that everybody is going to wake up in 2024 and compete is just that, speculation. The minister gives us, Parliament gives us an answer and says the new, because they refer, I may be taking it out of context, but they do refer to the fact that there's 332 political parties. And their assessment of that is that, up to now, these registered political parties have not sought it or deemed it wise to engage in the substantial expense of participating in elections. I'm just trying to find my page. The court will bear with me. But if that's the position up to now, why should it be any different in the future? What about the participation of newcomers into the electoral space will change that position? Who, in their sane mind, as a single individual, would want to invest as much money and resources in competing in an election if they weren't serious about participating? So,
if the IEC says we do have many political parties, but not enough political parties garner enough votes to contest the elections, based on that, we think that the independents also would suffer a similar fate. Would that be a fair assessment, or it's just speculation again?
speculation again. Speculation. We start with this basic proposition. These are actors in the same election, but they are different. Now, it may be that some political parties may enter the race frivolously to score points or to take away votes. But the likelihood of an individual candidate going through all that trouble, all that time, all that energy on a frivolous basis, in my respectful submission, in ordinary human experience, is limited. Unless
Well, no, sorry, lastly. If Parliament says, we have done a study, and after conducting the study, this is the conclusion that we've arrived at, to say, we can't be wedded to the old 1,000 number. We think the 15%, it's an appropriate number, and which would discourage any frivolous applicant, right? And government puts that proposition before us. Now, wouldn't one look at it and say, we look at the legitimate government purpose to test whether that decision is rational or not?
Yes.
And if that purpose is said to be rational, what can us as a court do except to enter into the realm of speculation like I've just done with you now?
And Justice Matopo, the situation that you're putting to me now involves what should have happened in this case, in my respectful submission. Not that the numbers were determined on the basis of legal advice, that they came down. We should have seen, as Justice Ackerman said in the first case in this court, and we've moved away from our past. If you want to pass a law, tell us. Give us the facts, give us the circumstances, not the chapter and verse, but demonstrate the rational basis for your decision. Now, if on these papers Parliament had come to court and said, look, we did this, we thought about that, we divided the physical proximity, anything other than the serious, too many people who are not serious are participating. Of this, we can't exclude that a sizable portion might be frivolous, and we need to make the elections manageable. There is nothing in here to demonstrate such an excessive increase from what went before.
Let me finish. But Parliament is not saying, or neither is it imposing an absolute barrier. You can still participate as independents. What Parliament is saying, we are now increasing the threshold. And this is where the problem is with your client, to say the increased threshold constitute a barrier. The Parliament says the reason why we increased the threshold, we conducted some studies, we call for public debate, for public comments. We arrive at that decision that says this is the appropriate ratio that you must follow. Is Parliament to be second-guessed there?
In that circumstance, no. But that is precisely what we don't have here. We have the Minister of Home Affairs who says, I considered OSA submissions. You have a Parliament saying, I considered OSA submissions. You have a debate, and the parliamentary record reflects this, a debate over time, but nothing about the specific challenge presented with respect to the single individual candidate. All that we see emerging from this record is that they knew that there had to be a limit. It started at 50, then it went down to 30, and then it went down to 20 because the minister was advised that that would likely be better to be defended. It was a uniform principle. But exactly what you're talking about, Justice Matopo, we don't see here. What was the research? On what basis? And that is why when OSA wrote to the President on the 16th of September, they said, but we don't understand the basis and the justification for this. And that was after the parliamentary process. So thank you.
Justice Mhlantla.
Thank you, Sir Chair. Just to follow up on this question, the IEC tells us that during the 2019 election, there were 48 political parties that contested the elections. And of those, 14 gained seats in Parliament, 22 did not even meet the 15% threshold. And then we have the evidence that what led to Parliament to change the decision from 1,000 to the 15% threshold. I just want to understand your argument. You are saying the independent should not be required to present these signatures, the 15% threshold. But, okay.
Yeah, yes. But not that we should be exempt completely. Sorry.
You want something lower. You want the 1,000.
Yeah.
But they are saying they've done away with 1,000. And they explain why. And then they also say, for all those registered political parties, whether it's 300 or 50, anyone who does not have a seat in the National Assembly will also be subjected to the same requirement. And that is found in Section 27 of the Electoral Act, the new amendment. So what do you say to that? Because it would appear that you are all in the same boat, basically, unless I'm wrong in the understanding of the legislation.
We say that 15% is not justified. Now, we know that it was determined upon the basis that the minister believed that that Parliament could make a legislative choice. But the complaint of OSA is, we don't dispute that, but to move from 1,000 that has held this country in good stead since the dawn of democracy, now, with elections imminent, from 1,000 to 1,400% increase, and you do so upon the basis that everybody, new political parties and independent candidates, must meet the same requirement. If there was some evidentiary basis on which that figure, as it was arrived at, could have been explained on these papers, maybe OSA's case would have been far more challenging. But there is nothing. That is what we say. All that there is an arbitrary sliding down.
Don't they explain that what happened initially started at 50%, and after consultations, it was reduced to 30%, and then there was all the concerns raised about that figure. It was then reduced to 20% and eventually to 15%. Are you saying that that explanation on its own is not sufficient?
We're saying that that measure as it is did not consider the impact that it would have in respect of two things: constituency-based measure, province, and the difference between political parties and individual candidates. But leave that aside. What we're saying is that 15% was unsupported by any demonstrable assessment of risk, any demonstrable assessment of what is the maximum number of pages the IEC can handle to ensure that free and fair elections are permissible. We don't have anything. What we are told is it may be, and it's impossible to predict, and there may be practical considerations, but we don't know how the 15% figure was arrived at, bearing in mind that it's a percentage of a seat in a province. What market research underlay this?
You know how 1,000 was arrived at initially?
No idea, Chief Justice.
Okay. Justice Kolopin.
Thanks, Ms. Gabriel. Just two questions. The first, you indicated the difficulty that independent candidates would have, and you used the example of the Eastern Cape. And I know you used it simply for proper effect. But in truth and reality, a candidate wouldn't have to go to 4,089 districts. Because if you need 15%, and if you were a very popular candidate, you could get it in one district. But I understand you were simply trying to illustrate the spread.
Not for public effect. I'm too old for that, Justice.
Okay, good. No, it does sound much more daunting if it suggested that a candidate would have to go to 4,089 districts and collect votes.
It's just to demonstrate the regions.
Sure. But my second question is this, is that it seems that all the parties recognize that if one sets the threshold too high, there's the real risk of violating rights. On the other hand, if one didn't have a threshold or you set it too low, there's a real risk that we may not have an efficient election, let alone that we may not even have an election at all. And so one needs to find the balance. As I listen to your submissions, you seem to suggest that it could be set at higher than 1,000. Your problem is that it's 1,000% more. And does the problem not lie therein that it's almost impossible to scientifically make this kind of call? Because how do you do it? I mean, foreign jurisdictions have help, but have limited help. Our own context is different. And therefore, one gets a sense that Parliament was really grappling with this difficulty. Not by an absence to apply their mind, but I think just the inherent difficulty of coming up with a figure that you could test scientifically. Now, you may call that arbitrary, but someone could say, well, it might require a bit of common sense and a bit of peering into the crystal ball, which I suppose we all hope we had here today. And so how does a court today make that determination? If we're saying that a threshold is important and is necessary, but we grapple with where to fix that threshold, mindful that it may well be a valid consideration that a political party has shown established support. An unrepresented party has not. An independent candidate would need to, and you need some mechanism to moderate that. And in the absence of anything else, that might objectively be an acceptable mechanism.
It's also is not unmindful of the problems. As to research, we know that there's research out there. We have wall-to-wall municipalities in this country. I cannot give you any further detail, but I know that there is electoral research. For present purposes, what we have is a class of entrants into the electoral space, pursuant to a judgment of this court, who intend to participate, at least some of them, in 2024. What we say to the court is, we can't ask you to gaze into a crystal ball, but we ask you to use the existing contestation requirement. That's 1,000 signatures. So what used to be applicable and is still applicable up to political parties, now today it's still applicable to register. According to the Electoral Act, that's a contestation requirement. Use that. There can't be anything controversial about that. And that legislature has spoken through that provision.
Even if that requirement may be uniquely related to the existence of a political party with demonstrable support. I mean, is that not a distinguishing feature that stands in the way of simply importing that requirement into the case you advance?
I have to step back and look at the nature and purpose of our democracy. Are we to assume in advance that the right to vote and the right to equality are in and of themselves valuable things for democracy? Because if we approach it from a negative basis, then we see these as obstacles on the way to an election. And in our respectful submission, the cases that we set out in section B of our heads of argument say all arms should be bending over backwards to accommodate elections, to accommodate the right to vote, to accommodate a healthy and vibrant democracy. Those are my submissions on that score.
The Deputy Chief Justice has a question for you.
Thank you, Chief Justice. I'm still not sure that I'm happy, I'm satisfied with your answer to the intractable challenge of fixing a threshold, but I don't think you can take it any further, so I'll let that one go. I just wanted to take you back to the IEC, the Electoral Commission concerns, which were raised with you earlier by the Chief Justice. That is the risk, one of them, the risk of a lengthy and complex ballot, and there's a host of other challenges that the Commission mentions: risk of voter confusion, risk of voting itself taking longer, spoiled votes, and so on. You repeatedly submitted that they have not, that the Commission has not actually said it would be impossible to run the election despite these challenges, maybe just difficult. But as I understand the submissions by the Commission, these are serious challenges which could potentially threaten the integrity of the election process. Should they be ignored still? I'm just worried about that.
Then we come to the, I accept the concerns that you're putting to me, Deputy Chief Justice. And the IEC does raise those concerns, but it raises it at a point at the level of risk. For instance, in paragraph 27, this is the level at which the IEC has responded. Importantly, the trend indicates that the signatures requirement Rogers. I accept that.
Thank you.
Justice Keepers.
Just one question, Ms. Gabriel. Does OSA accept that if a candidate cannot get between 10 and 14,000 signatures for the National Assembly, she's unlikely to get 6 times that amount in order to meet the quota for a seat in the election? If not, why not?
We don't accept that, because that is a projection by the Independent Electoral Commission. The nature of a democracy is that you get into the process and you participate and you debate, and the democratic process itself will determine what happens to you.
Except, of course, Ms. Gabriel, that this statistic is based on a past election. So it's not something taken out of the air. It's a general kind of standard saying that you have to get at least 6 times the amount of between 10 and 14,000 signatures in order to qualify for a seat.
Well, 2 responses. The legal response is demonstrate a fully justified reason to limit the right. The second response is the statistics up to now have been based on organized groups of political parties. The debate we've just been having with Justice Rogers is that is not necessarily a predictor for independent candidates. It can't be accepted as a reliable predictor, because ordinary common experience or common sense suggests that you're likely to have far less frivolous participants as independent candidates, assuming that that's a basis on which to limit rights. But the assertion that if you can't meet this, you are not a serious contender, we submit as flawed.
Yes, thank you, Chief Justice.
I think there are no further questions, or there's one more question.
Ms. Gabriel, what exactly is the threshold that you would like us to set if we have to look at a remedy? What are you aiming at? Are you happy with the 1,000 signatures?
Yes, because it's an existing standard in legislation, described as a contestation requirement.
Well, if that is so, then you accept that there must be a limitation of the right, because the 1,000 signatures, whether it's 1,000 or 10,000, places a limitation on the right that you say is infringed.
No, we don't accept that that's a limitation on the right. We accept that as a pre-election standard. It's not an exclusion in that circumstance, because people are familiar with the standard. It's been applied over the years.
But you accept there should be a limitation. There should be a threshold.
Yes, and that's
so the right is limited. It is limited to the extent that you have to get at least 1,000 signatures. So yes. You accept that to be the case.
Yes.
So then the only issue that we have, that we are dealing with, basically is the number of signatures that must be obtained. Is it not so?
We've demonstrated.
Is your case that you cannot obtain the number of signatures which has been set in the amended Act?
That's the basis on which we participated. We said this is unreasonable. It's a barrier to entry.
No. Is your case that you cannot meet that number?
Yes. The 15%? Yes.
Why do you say you can't meet that?
Because we have members who intend standing. All along they knew if you link this to this constituency, it's going to be almost impossible. And it's on that basis that they participated and said this is an unreasonable, arbitrary barrier to entry. We will accept ordinary regulatory principles as it affects fundamental rights. But where the restriction becomes so onerous that it becomes a bar to entry the process, then that is an unjustifiable limitation on the right. Our Constitution permits the limitation of rights, provided they are justified.
Thank you. Thank you, Ms. Gabriel. Is it convenient to hear the amicus now, I think, or not?
Chief Justice, in a case without a burden, I don't wish to be a further burden upon the court.
Yes.
I'm perfectly happy to begin arguing tomorrow morning, but I'm in the Chief Justice's hands.
Yes. Well, I had mentioned that if we reached 4 o'clock, we might have to proceed tomorrow. But we can, if everybody agrees, we can go up to 5. But of course, there is always the concern that we go up to 5 and then we don't finish, then we go to tomorrow anyway. So I'm just looking at my colleagues to see whether they say 5 o'clock. It's 5 o'clock. Is it fine with council if we see how it goes with 5 o'clock?
Chief Justice, we are of course in your hands. It seems to me remote that we will finish by 5. Because
Yes.
Still Ms. Blair and myself and then a reply. But
Yes.
of course,
Well, one of the things that is quite important, of course, is that issues need to be dealt with properly.
of course.
And of course, if we go to 5 but we don't finish anyway, then we might say, well, maybe we may as well go to tomorrow and have matters dealt with. But let's take a short comfort break and then we'll come back and then we'll take it from there. 5 minutes. We adjourn.
Let me finish. I actually have a problem tomorrow. Chief Justice, excuse me.
We think, yes, he wishes to be released.
Justice, we didn't want to be rude. Wanted to
Yes.
find out if we can be excused because we are not participating in this case.
Yes, you are excused. We are done with the earlier matter.
Yes.
Yes.
Thank you, Justice.
Thank you. We have had discussion, and it seems to us that it would be better that we adjourn to tomorrow to have the rest of council deal with the matters properly, because it's unlikely would be done by 5. Is that fine with all council?
Chief Justice, I have a difficulty with tomorrow.
You do? Uh-huh.
I was going to try and make a plan.
Oh, I'm sorry.
And maybe this is the plan, which is to propose that if I might argue, because I'm only allowed 10 minutes.
10 minutes, yeah.
And then we can at least finish the, let's call it the applicants plus amicus case for the day. And I've discussed it with Mr. Budlander, my learned friend, and that they can then have a break and start tomorrow. But I'm in your hands.
Okay, so you are asking that we hear at least your argument, which should be 10 minutes, subject to whatever questions, and then we can then adjourn to tomorrow.
If you have the strength for that,
yeah.
Justice.
Okay, all right. Let's do that then.
Thank you, Chief Justice.
Thank you.
As amicus, Rivonia Circle wishes to assist the court with submissions about entry on new entrants. I stress we're speaking about both independent candidates as well as political parties contesting the elections. We say the barrier is not a small thing. There are 3 striking features about it. Firstly, it's a self-evidently burdensome barrier for new entrants, and Ms. Gabriel has already demonstrated that in her address. And with respect, the debate about percentages and sliding scales, we, with respect, say is a distraction. It's the physical numbers, it's the real numbers that do the harm and that amount to the barrier. And as I will show you, external legal counsel led by eminent present counsel in this court advised the minister that they thought that the figure of 14,667 signatures was too burdensome and that it would likely lead to unconstitutionality because, they said, it was too high. And of course, new entrants start on the back foot. We know that new entrants don't have the advantage that incumbent parties have of enjoying state funding. And we know that they already have to show their political worthiness by raising funds for a deposit. So this barrier, moreover, Chief Justice, was designed to be burdensome. While the motive is said to be rationally inspired, cut the political wheat from the frivolous chaff, that shouldn't dull us to the fact that the burden is designed to cut, like the CJ's timer, and it's going to do so in relation to an election that is just around the corner. Here's my second point on the burden. It's not an ordinary cut. It's not a barrier to a commercial market or a barrier to entry to a club. It's a barrier to ballot. So it's a burden that befalls new parties and independent candidates for the first time in our democratic history, precisely, some might say, when the country is critically in need of political contestation and new ideas. Political accountability and contestation cannot happen if you don't even get onto the ballot or vote for new blood onto that ballot. And if this entails a burden on foundational rights, it's then a burden fundamental to our history, but it's also critical for our future. Thirdly, this burden was imposed by Parliament, not independently by the Commission with the benefit of proper time. That is so despite the same external counsel repeatedly advising that it would be preferable for any burden's details to be decided independently by the Electoral Commission, in regulations if necessary. The ministers' heads of yesterday are stridingly defensive on this score. Paragraph 54.1, they say factually there's no evidence to support what appears to be Rivonia Circle's insinuation that parties in Parliament sought to stack the cards in their favour. Well, Justices, it's not an insinuation that we make. It's an apprehension that we have, and it's a reasonable apprehension. If you want evidence of that apprehension, it's in the Council's opinion that was given to the Minister of Home Affairs at page 1591, paragraph 14. There, the Council said that they saw substantial advantages to vesting the decision with the Commission, and they repeated that in other opinions as well, because they said, and I'm quoting them, it would avoid any complaint or perception of partisan politics attempting to thwart the participation of independent candidates in elections, and would provide a measure of flexibility so that the requirement can be adapted in accordance with experience in running elections. Let me then turn immediately to the two arguments we want to make. One is on interpretation and the other is on limitation. Interpretation first. The respondents repeatedly say that 15% isn't a burden and that there's no evidence that it violates rights. Well, the Constitution and this Court's judgments tell a clear story about these very rights in issue and how they have to be interpreted. One understands a burden upon you by appreciating what it is that you're entitled to. That interpretation is therefore critical to assessing the permissible limits or burdens that may be placed on these rights. There are three quick takeaways. First, this Court has articulated the importance of the nature of these rights at stake repeatedly. It has said that the Constitution protects the right to participate in elections as a candidate and seek public office. It is said that you're entitled to do so in calm, to compete with one another on relatively equal terms, said this Court, and this Court said that you're entitled to a level playing field in which all participants can compete without any undue hindrance or obstacle. That too was said in calm. So we know we're talking about the right to seek and hold public office, to compete on a level playing field, and to do so without undue hindrance. Second, this Court has explained what weight must be given to these rights. In calm, it set the scale. It said that this Court must give full weight, that was its words, to the constitutional commitment to free and fair elections and the safeguard, it said, it provides of the right and ability of all who so wish to offer themselves for election to public office. And it has repeatedly in election cases said that one must generously interpret the rights in issue. It said so in August, it said so in Ramakatse, and it said so in New Nation Movement. What would such a generous interpretation mean? Well, in our respectful submission, it would mean that while Parliament may regulate, Chief Justice, it may regulate access to the ballot, it must do so carefully. It must be properly interpreted through these rights and in harmony with other political rights. It must ensure that any restrictions on the ballot access neither constitute an unreasonable barrier to entry nor lead to an uneven playing field, the very words that this Court used in Khan. Third, given the importance of these rights, the legislature, when it legislates in relation to these, not regulates but legislates, is bound under Section 8 of the Constitution to respect the rights in the Bill of Rights, and Section 7, it has to respect, protect, promote, and fulfill the rights in the Bill of Rights. And in Richter, this Court underlined the pronounced positive Section 7 duties in relation to the right to vote. It said, at paragraph 54, unlike many other civil and political guarantees, the right to vote imposes an obligation upon the state not merely to refrain from interfering, but to take positive steps to ensure that it can be exercised. And we say that it follows that Parliament is then obligated to take reasonable and effective steps to respect, protect, promote, and fulfill these critical rights. How does it do so? By ensuring that as far as reasonably possible, there's a level playing field in which all participants can compete without any undue hindrance, and by giving full weight to the right to participate in elections as new entrants. That leads me then to justification. The respondents, Chief Justice, have not properly justified in at least two ways. First, they've not shown that they've investigated the actual impact of such a measure on new entrants or allowed the Independent Electoral Commission to set it as an independent body. Notably, the experts that the Commission briefed, at page 202, you'll see Mr. Halfdan Linge of Wits was never asked to consider the impact of the signature requirement. The Commission has commissioned one expert report, and it was into the issue of the 200-200 split. It didn't ask for any expert evidence in relation to the signature requirement. And as I shall show you, there's no evidence that the Commission ever did any study about the 14,000 signatures that are the impactful ones that we're talking about, 10 to 14,000 signatures. They never did a single study of their own. Justice Matope was asking the question earlier, where's the evidence? There's no evidence. They didn't do a study about 14,000, what it means, what is the impact on rights, will it hinder the access to the rights that are so dear to South Africans? No study whatsoever. So there is no study that they did to consider less intrusive means. And what that means is that we've got a further incredible difficulty. We know that it was critical for them to do that investigation. They should have done it properly because of the high number that 15% generates. This Court knows that from the opinion given by the learned counsel in this Court at page 1601, the Portfolio Committee was, you'll see this in the opinion, you'll see paragraph 19. This is said by our learned friends. The Portfolio Committee is proposing, page is 1601. The Portfolio Committee is proposing that Parliament should adopt a formula in the legislation to determine the required number of voter support with reference to a percentage of the quota, and has landed on 30%. There's no indication of how. In principle, we repeat, we're of the view that using a formula would be a rational approach. However, 30% appears to us to be too high. Why? Turn over the page at 1602. Because it would require an independent candidate to demonstrate the support of 14,667 voters in order to contest an election or votes. So we know that the number's the radical problem. That number, forget the percentage, 14,000 plus is on our learned friends' own arguments, as they advised the minister, too high, it's a burden. They said at paragraph 24, even if the support could be obtained using electronic resources, it may be impossible for a candidate to obtain such support, especially if they're only able to gather signatures in a limited time provided for in the electoral timetable right before the election. And in our view, such a high threshold of 14,000 plus signatures is arguably an unjustifiable limit on Section 19. So we know there was no study done after that to figure out what extra work needed to be done to understand the limitation on rights and the impact on rights. And there's no evidence further that any investigation was done of comparative studies. We have the most peculiar thing. We have the Independent Electoral Commission saying in its answering affidavit, Denmark is a good idea. We have shown in the short time that we've had available as Rivonia Circle, numbers of comparative jurisdictions where the barrier at a numbers level is set lower. And the 1% Venice Commission criticism that's been made against us, I may have to deal with that in questions, is to miss the point. Europe is different. Other places are different. The barrier in numbers is what is ultimately an issue here. And there's not a jot of evidence, Chief Justice, you can cut me off. You'll know what I was going to say, that any comparative study was done. Thank you, Chief Justice and Justices.
The basis for saying 14,000 is too high is the numbers and not 15% per se. Because if it was 15% of 100, maybe there would be no complaint. But it's when the numbers go up, that's where the complaint comes from.
Chief Justice, it's the percentage translated into real terms in a South African population, as populous as we are. That's why the 1% Venice example, for instance, doesn't work. And we've been criticized as Rivonia Circle for having relied on the Venice principles. We urgently tried to assist the court, but when we looked at it more closely and had the benefit of seeing our learned friend's argument, we realized 1% in Europe is in respect of constituency-based systems. In South Africa, an entire province is a constituency. The entire national electorate is a constituency. So 1% could never do that type of helpful work. So you have to ask the question, what is, to use Justice Rogers' expression, what is a common purpose understanding of what would be a hindrance here in a South African world? One can know that 10 to 14,000 is a serious number. We know already, as I was highlighting, from the opinion that was given to the Minister of Home Affairs, that our learned friends themselves recognized that the number of 14,000 was a high number, too high to withstand constitutional scrutiny. So it's the translation into real numbers that really does the damage, Chief Justice. That's where the burden lies. And it's a burden that we say with respect is peculiarly important to recognize at this time because it's just been imposed. It is something that candidates are struggling to understand as a new imposition, and it's something that they are going to have to grapple with and overcome between now and the end of February, as we understand the Electoral Commission to say, because that's when the candidates are going to have met the requirements for registration. So it is a burden which is compounded by the shortness of time, and it's a burden which comes in this particular moment of South Africa's history, where one should be encouraging actively more people to be on the ballot rather than fear.
Justice Theron.
Thank you, Chief Justice. Mr. Du Plessis, what informed Parliament's decision to set the requirement at 15% as opposed to another percentage? We know there was a change from 50 to 30. 20 and then 15. So what informs the 15%? That 15% is more likely to pass constitutional muster as opposed to another percentage?
There's nothing. What you have, Justice Theron, is you have the evidence of Parliament, obviously, in this court, where it simply says that there was a suggestion that there was a concern about a high percentage, and that through legal counsel's advice, the percentage slid down to eventually being 15%. That's the evidence that you've got. What you don't have in any way at all, and of course, if we've missed this, it will be pointed out to us. But we have looked through all of the, and this is important because of the refrain we've heard, which is that Parliament did a great job. Parliament worked very hard. Well, of course, that's commendable, and we would hope that Parliament always works this hard. But that's not an excuse as to whether the real issue was interrogated by Parliament. Namely, we've got legal opinions, that's one thing. But did the Independent Electoral Commission or Parliament at all ask itself whether that 15% was going to be impactful on rights? How impactful? And whether there was anything beyond that?
Where does that leave us if that was not done?
It leaves us with, well, some have said an arbitrary decision. We don't need to go that far. We say that it's a decision that certainly is not shown to be reasonable and justifiable, and which definitely meets the, it does not meet the requirements under Section 7 of respecting, protecting, promoting, and fulfilling the rights in the Bill of Rights. Because if you're Parliament and you've got a duty to respect, protect, promote, and fulfill rights in the Bill of Rights, and you know those rights are critical to South Africa's history and to those that want to debate more meaningfully and contest elections for our future, then you will ask this simple question: how do we ensure that a burden is not too much of a barrier, not too much of an unreasonable or unjustifiable one? You interrogate that. And you do so. You've got experts. We know that the Electoral Commission commissioned an expert report on the 200-200 split. Why did they not do the same in relation to the signatures? And similarly, why do we only find the Electoral Commission thinking about Denmark in its affidavit before this court? Where was the comparative reports and experience that it could have garnered over 2 years' time? We did it in 4 days with great respect, under a lot of pressure, to find what we thought were comparable jurisdictions. Each of the comparable jurisdictions, which we think are helpful with respect to the court, at least show you that you're talking about a much lower physical barrier for purposes of signature requirements. Denmark is not even comparable. It's different socioeconomically. It doesn't have the same history as ours. It's got a very high voter turnout, so there might not want to be a need to encourage more people to get onto the vote. There are numbers of differences. None of it's explained by the Electoral Commission. So to answer your question emphatically, and to give you the reference, my junior has provided me with a page. It said at page 837, Justice Theron, and I'm assuming this is in the affidavit. It's the opinion. It's the opinion, excuse me, it's the opinion that was given to the Minister of Home Affairs on the 1st of February 2023. This really is it. It's the opinion that says at 16.5, if the National Assembly is concerned that 20% is too high, it could consider reducing it to 15%. But in our view, the National Assembly is appropriately placed to make this call. That's it. So, as to a study, there's none. As to investigation of the impact that 15% would have on rights, there's none.
I must say that from the comparable jurisdictions that were put up, the 15% requirement seems vastly different. And from what has been put up before us, there's no other jurisdiction that has such a high requirement.
No, there's no other place that we could find comparably. We did our best to be fair. Justice Rogers, am I trying to answer your question as well? Sorry. No, sorry. I saw a hand raised, sorry. We attempted to be fair, Justices, when we were extrapolating what we thought were comparable jurisdictions. And in each of them, we didn't choose them because they were low. We chose them because we thought that they were helpful comparably. We're talking about Canada, Kenya, India, Turkey, Germany, which has a similar system to ours. In each of them, you're looking at a significantly lower physical hurdle in the form of the real number.
And in terms of the new system, would the 15% apply to political parties as well?
Yes. So under Section 27, it would be applicable to both political parties and to independent candidates. And in fact, I think it's the Minister of Home Affairs that says, well, therefore, it's now rational, because in the past, it was something that was going to be applicable to independent candidates, but then they cured that by also making it applicable to new political parties.
Yes. Now, some of the respondents have said that the applicant has put no evidence before this court to demonstrate that the 15% signature requirement is impossible or difficult to achieve. Is that a right approach?
No.
Considering that it's the respondent who bears the onus to prove that the limitation is justifiable, can the respondent on who the onus rests come to court to say the applicant hasn't led that evidence?
Justice Theron, firstly, that is absolutely right as a matter of our constitutional law. It's for the respondent to justify. Secondly, it's a particularly onerous burden on the respondents because they bear a positive duty. So they need to show how it is that they've not met that positive duty, because it's only upon their shoulders that that duty rests. And then thirdly, this court, in at least 3 cases that I can recall, I didn't have the time while I was listening to the debate to find the authority citations, but you'll know them, your clerks will find them soon enough. In August, which I wasn't in, but in Richter, which I was in, and in this court's decision more recently about extending the municipal, or the attempt to extend the municipal election date, I think it's called the DA case. In all 3 of those cases, the same argument was run by the Electoral Commission. It's going to be incredibly burdensome, going to be very difficult. We can't do this, it's not going to happen. In fact, in the DA case, it was said that it was going to be impossible to hold the elections by the time that the Constitution stipulated. And this court said, well, that may be so, but it's not impossible, and if you can do it, you must do it. And as it turns out, it was possible. Certainly we had the municipal elections and no disaster happened. The simple point, though, is that impossibility is not something that's been raised. It's not been said that it's impossible by the Electoral Commission or Parliament. They've raised arguments about difficulty. But of course, sometimes in rights cases, in order to ensure that new parties and new incumbent independents, independents who wish to participate along incumbents, they need to be given that leg up. And that is an opportunity which should be embraced rather than abjured by the Electoral Commission, we say.
Mr. Du Plessis. The respondents also make the case that the signature requirement ensures that the ballot is not too long or too complicated and that the process is manageable. Is this a legitimate concern?
We accept that it's a concern and it may well have legitimacy. And of course the Electoral Commission, we don't say in any way has been acting in anything but good faith in attempting to discharge its obligations. But that's not the constitutional test. The test is whether it's impossible and it's not impossible. And to the extent that it's difficult and more effort needs to be put in to ensure that it can be done, well, then that has to be done.
And my last question. It seems now when an individual signs to support a candidate or a party contesting the election, they must put up their names, their signatures, and identity numbers. Was this a requirement under the Electoral Act? And what has motivated or prompted Parliament to make this change?
What we understand is that there was a requirement always for you to have to put up 1,000 signatures if you wish to be registered as a political party. But in relation to having to now, in fact, be contestable to meet the contestability requirements, this was never an obligation upon you. And that's where we have raised what we claim is the very significant concern around secrecy of votes, because that wasn't, it seems, factored into the thinking by the respondents at all. We are saying that when you have a multitudinal amount of people having to put up their hands like this and publicly declare their support, well, then you do stand the risk of a difficult debate about Section 19.3 and whether there is a risk that that type of secrecy is then undermined. What we know is that it didn't feature at all. There is nothing that suggests anywhere that the issue of 14,000 people having to put their hands up And it's not way before when you're registering as a political party. It's in the run-up, it's in the heat of battle, it's in the contestation as you're heading towards the elections that you've then got to show your hand like this. When parties are at loggerheads, when the country is getting into the political turmoil that elections ultimately entail, it's at that point you've got to put your hand up. And we say that that is a serious concern. We therefore say that that too is a consideration that needed to be taken into account.
The last question, Mr. Du Plessis, and I think this was raised with Ms. Gabriel as well. So the requirements of the signature, is there a direct link between the number of the requirements of the signature and to say that if this person cannot muster 15%, then the possibility of being slightly successful in the elections is very remote? Or do we look at it from the angle that we give the person or the party an opportunity to participate, an opportunity to canvass and to seek votes? Who knows what will be the results after the person has had that opportunity, rather than excluding them right from the get-go?
There are at least 3 points to be made, Justice Theron. The first point is this. It ignores, as I think Ms. Gabriel pointed out in the
Sorry, before you answer.
Of course.
Is there funding that the candidate who's registered for gets from the IEC in any way?
Not as we understand it. The only funding that's available is under the Public Funding of, and the title tells you everything you need to know, Represented Political Parties Act. So there isn't that funding available. So the first difficulty is that, of course, there is this idea simply ignores the fact that such onerous signature requirements have to be considered alongside the other burdens. But the bigger problem with respect is that it ignores that parties often start slow. They're slow. They get into the election slowly, and then they grow precisely because they are able to campaign and they resonate with the electorate, and they then begin to have that impetus that moves them towards. I too am not good at maths, but I think it's a bell curve. You start like this and you go up faster. And that's why when you get closer to the election, you may well meet the requirement of whatever the particular moment is. So 15%, by the way, was not a figure that was chosen in any way on the basis of an investigation of what the optimal figure would be to ensure that parties ultimately are able to compete in the election later. But in any event, it ignores entirely this point, that it's precisely that you want to encourage parties. Of course, you don't want to encourage everybody. You don't want to encourage the frivolous. We appreciate there may be a particular floor above which you have to climb. But to set the ceiling too high means that you are excluding numbers of people who may have got into the room and found themselves generating a huge amount of political energy and momentum. That would simply be ignored if you use the process that our learned friends suggest for. And of course, there's a further difficulty. We already know 14,667 on the opinion that was given was a figure that the external counsel said was already too onerous. So we know that it's too onerous to meet. It's not a question of whether you might meet it under 15% later or not. It's too onerous.
Thank you, Mr. Du Plessis. Thank you, Chief Justice.
Thank you. I don't see any further indications from my colleagues. Thank you very much, Mr. Du Plessis.
Thank you for the opportunity. Thank you, Justice.
Thank you. We are then going to adjourn until tomorrow at 10 o'clock. The court adjourns.